wherein the single jury is allowed by this. After the interview has come, the bill has almost been heard by the Hon'Ble Chief Justice, but the assignment having been changed. He is also directed.
What you want?
Listing, you want
You want
listing.
biography of the case, or you want to have some relief at our hands? What you want?
I want the listing of the
Give
material
that.
on the hearing, any day may be fixed.
Which year?
Of the year 2025, but relating to appointment matter.
Appointment of which year?
23.
23, 24.
23 matter.
No.
24 I had filed the case, 25 appeal.
My lord, one fresh admission writ appeal matter.
Day may be
There are many other people who are waiting in the queue. We cannot jump the queue.
No,
Yes.
One fresh admission writ appeal matter. The retired employees of the housing board are not getting pension despite the clear statutory provision on the grounds of that they are having financial constraint.
On that note,
My lord, only that.
2 weeks.
2019 matter. Retired since 2014.
fresh admission matter, fresh admission promotional matter.
Yes. 3 weeks.
Appeal preferred by the state,
What you want?
listing, your lordship, because the petitioner is not the sufficient allowance for 3 years, your lordship.
Time, give it. Morning time is very, very precious to me, to us.
My lord, on your board matter, my lord, item number 31. My lord, my learned senior Mr. N.K. Mr. Senior Advocate is in accommodation. My lord.
What you want?
My lord, any other date, he is in accommodation.
31. But you have informed the other side. Can you grant time? Which year?
And 22.
2020. Yeah. Finally. After to call after 2 weeks, finally at the request of learned counsel appearing for the
My lord, I am of the opposite party.
Gopis.
Can it be fixed on?
It will come. We don't know because we don't know how it will work. Yes.
That I finally mentioned the fresh addition. Against the order of CV.
To mention, your lordship, this writ appeal is squarely covered by writ appeal number 1222 of 2025.
Which writ appeal?
Your lordship.
All right, you. The next week you is posted. All the same.
2 matters are same. And lordship, this is a fresh admission matter.
It will come after 2 weeks.
Obliged.
Item 1. Yes.
My pleasure.
Yeah.
My lord, before proceeding with this case, my lord, I have just prepared only the 2 copies for the process, my lord. That is the brief of the original application before the learning cat, the counter filed by the opposite party, my lord, who are the petitioner before this Hon'Ble Court, and the rejoinder filed by the petitioner applicant in that case. Only that comparison, my lord.
They are there part of the record.
Yes, they are the part of the record, my lord. That is what, my lord, for better appreciation, my lord. Yeah. My lord, in this case, my lord, here the order of the learning.
Why we have put it to the top of the list?
My lord, on the last occasion, when this metro was listed before lordship, but it could not reach. And there was a content proceeding which was going on in the
Other
for the Central Administrative Tribunal. So taking note of this same, my lord, your lordship had pleased to put up this matter today, but on the request of my lord, your lordship put it as a to be heard as a first case.
ESI is the
Yes,
petitioner.
yes,
Your panel counsel for ESI.
yes, my lord.
Okay.
But the case in short, my lord, without taking your lordship to the record, my lord. In short, my lord, I may be permitted to press that it can be easily sorted out. Here it is a case, my lord. The petitioner is the applicant before the learned cat, my lord. He is a Group C employee.
Petitioner was the applicant. It is coming.
The applicant
was the
applicant before the learned cat. He is a Group C employee. He wants a transfer from one region to another region. So for that reason, my lord, an intra-region IRT policy of 2022 was in force.
Intra-region.
Intra-region
Within the
transfer.
region.
Yes.
Within the region.
No, sorry, man. Inter-region.
Inter-region.
Inter-region. Sorry. there is an inter-region, the policy matter, it covers both inter-region as well as inter-region matter. So with respect to that inter-region transfer matter, that is a policy of 2022, the applicant before the non-cat panel or the opposite party in this case matter, he applied in terms of the same. And a list was prepared on the basis of the different applications submitted by the different persons. A list was prepared in the year 2023 by March 2023. But later on, my lord, that particular list could not be operated. So it was decided by the head office, my lord, that that particular list will not be operated. And that has stand cancelled. That is Annexure 6 to the original application in the month of October 2023. Challenging the same matter, the applicant before the Law and Cat matter, he approached before the Law and Cat with a prayer to quash the same and to allow the transfer, effect the transfer, as it has been approved and the select list, as a list has been prepared. That was taken into consideration. We filed a counter before the Law and Cat on two grounds. One is that transfer is not a condition of service, it is an incidence of service.
But once you draw the policy,
But that is a policy, and he also exercised his willingness, and that willingness has been accepted. I admit, madam. I admit to that.
partakes any standard book on service law will say transfer is not a condition of service. But if it is a policy is drawn, it partakes the character of condition.
Yes. Now, madam, coming to the second point, that particular policy which was effected and in terms of the same, the present opposite party, he applied and the list was drawn. Since that has been cancelled, that was a subject matter for adjudication before the Law and Cat. There was a specific prayer to that effect, madam, to watch that particular. This identically in different cat, madam, such type of petitions were also filed. In those cases, the documents are annexed, my lord, that with respect to the different decisions of the different cat.
What they do? What will they do?
They decided the matter in favor of the applicants, saying that this particular decision is quashed with respect to the respective applicant only.
Correct.
Our stand is that.
Inter-party.
Yes, our stand is that. Because it is a matter relating to transfer, taking a decision with respect to the personal difficulties of the particular person, when he approached before a particular competent court of law, that has been taken into consideration, and because such IRT policy has to be interfered so that the person can be transferred from one region to another region. That is why a specific direction was issued interfering with that particular decision, cancelling that decision only with respect to that particular applicant, and there was a direction for consideration. And these matters were also carried from to the Hon'Ble High Court, so also in some cases before the Hon'Ble Supreme Court. And this matter was decided, and accordingly that order was implemented. Now, relying upon those decisions, this case was filed. But here another additional factor was there. What we brought to the knowledge of the Hon'Ble Court, that after the cancellation of the 2022 IRT policy, the 2020
policy itself is cancelled.
And 2024, in October 2023,
after the cause of action arose or prior to?
After the cause of action. After the cause of action means preparation of the list.
When he had applied for transfer, policy was in update.
Of course, a list was prepared, accepting his consent. That was the policy was in force. But before it could be implemented in respect of not only in the favor of the petitioner or the applicant before the Law and Cat, in respect of anybody, whose name is appearing in the bill, that was decided not to implement.
Whether some of them were before the CAT?
Yes, in different CAT before different bench.
So all they have got relief in their favor?
With their decision that this particular order has been quashed in respect of them.
Okay, correct.
Yes.
And why he should not get that benefit? How can some of them approach the High Court, took the matter to the High Courts?
Our submission, my lord,
and a few of them to the Supreme Court?
Yes.
You failed?
Yes. Our submission before Lordship, my lord, in this case is distinguishable only for the reason that the two things, my lord, are differentiated from the previous other case. Here the decision, while the Lawrence Cat, my lord, took a decision, the Lawrence Cat was aware about the fact that a new policy has already been introduced in the year 2024. He did not whisper anything on the same, and there is no indication with respect to non-applicability of that particular cancellation notification with respect to the present petition.
No, why he should do? His application is, his request is under the earlier policy.
I think, my lord, I could not properly question. My lord, there are two things. In all the other cases where the non-cat had decided in respect of the different applicants, there is a specific observation that the cancellation notification with respect to that particular applicant is not applicable. Such observation is not there in this present case.
How then? Makes no difference.
My lord, that the resolution is in force. Cancellation
treating argument.
My lord, my submission, my lord, a cancellation resolution is in force, and a new resolution has already been modified.
That makes no difference. Unless it says the new policy rescinds the earlier policy with retrospective effect.
No, there is no question of retrospective effect, my lord. I admit that, my lord. That I am saying. And I have the only thing, my lord, that there is no whisper with respect to the discussion with the subsequent policy. So also, there is no discussion that the cancellation policy is not applicable to the petition.
We'll say that no. I will say that no. You made your efforts. We appreciate. You have wonderful articulation. And articulation will be wonderful when case is weak. That also we tell you. Nobody would have articulated the points the way you have now. No. But that will not increase the merits of the case when the merits are lacking on its own.
It is a fact, my lord, that the cases of the others have been implemented. That I admit.
We make the project cost. It's a case for cost because so many employees went to several tribunals, secured relief in their favor, and you challenged it before various high courts. You lost, and you went to apex court in few of them.
Yes.
You lost.
But only with respect to the personal cases.
Correct.
But not
transfer matters are personal only.
My lord, my limited submission, my lord, the policy relating to introduction of the IRT policy, the policy relating to the cancellation, that has not been interpreted by any court.
We'll say no.
My lord, since that is in
Because a policy is superseded, does not cause, it is not suicidal to the cause which has already accrued. How causes of action take birth, and how they evolve, and how they commit suicide or they are murdered. If you see that the graph, once cause of action arises, and it becomes cohate by certain factors, lapse of time, etc. Those do not die unless the new policy says the earlier one is superseded, whatever rights are accrued thereunder are put to rest, laid to rest, and all will be considered under this. And it cannot be like that because you are an instrumentality of the state. An instrumentality of the state is required to conduct itself as a model employer. Bhupendranath Hazarika versus State of Assam. You are not, it's not a laissez-faire era where I want, I will do, I do not want, I will not do. It's not like that. A state employer entity under Article 12 cannot act like the East India Company. It cannot. It has to be, you have seen that. E.P. Royappa versus State of Tamil Nadu, 74 Supreme Court, 555. All actions of the state should exhibit fairness. All actions. And now it has traveled to legislative level after Shreya Singhal versus Union of India. Even statutes are being struck down where they are manifestly arbitrary. Manifestly arbitrary is question of degrees of arbitrariness, not kind of arbitrariness. Therefore, you can't be that selective.
My lord, my limited last submission, my lord, in this case. My lord, in this case, my lord, we are not selective. The only what I presented before Lordship, my lord, that there are decisions by the different courts. Even, my lord, there are decisions with respect to consideration of the representation. That were also taken into consideration because personal decisions were also, personal difficulties were also taken into consideration as per Shilpi Bose case, my lord. We are bound. We are also, we cannot shut our eyes, my lord, when there are genuine difficulties. We have accordingly, my lord, considered the cases and implement.
But you have cancelled the list on a wholesale way.
My lord, that is in respect of all, my lord, and that is still in force. And thereafter, my lord, the new policy has been taken, and that new policy has already been invited into petitioner, I think, my lord. I am not sure. I think, my lord, the petitioner also.
Where is your new policy?
My lord, that I have already included.
Show that. How it reads. It abolishes
If a lordship will, if a
rights
lordship
that
will
have
come to,
accrued under the earlier policy.
my lord, if a lordship will come to this compilation, my lord, the counter, that is annexure R/1. My lord, the second
Page number?
my lord, it is at page number 9 to 25, my lord. My lord, that is the second one. Second one.
It is an option discharged by the employee on your request, or it is a voluntary representation from the side of the employee?
No, once we invited the applications, thereafter.
You wanted the
Yeah.
employees to opt for the
Yes,
transfer.
yes, yes.
Initially, this
And it's
policy
a
was
core of
not
the-
there. It was intra-region.
Yes.
You made a policy for intra-region and asked for option. Accordingly, he discharged his option. Now you cancelled that option.
Yes. The second one, my lord, the new
Page
policy
15.
that is R/1, my lord, this,
Page number?
in the present read, my lord.
You have, so, has he given copy to you?
Yes, my lord.
May I permit place matter, my lord?
One second. Yes. Yes, brother, which is the
My
new
lord,
policy?
You have
My
cancelled.
lord, only thing, my lord, your lordship may peruse that 2024, that is 40 to 56 and so 4, my lord, in the present read petition.
$32.
40, my lord.
40. This is a new policy.
This is a new policy, my lord, and if your lordship will come to the running page 42,
Good.
the last paragraph. Running page 42, the last paragraph. E. Introduction E, my lord.
This transfer policy supersedes all the policies previously circulated on this subject by so and so, so and so. All the
Including-
policies supersedes means it is always prospective.
I admit that. I admit that. So, my limited submission, my lord, what I was trying to place it before lordship, that at the time of adjudication of the matter before the Lord Cat, because the matter was disposed of on 4/4/2025, this particular fact I had already brought to the knowledge of the Honorable Captain. And second thing, in the final order on 4/4/2025, there is no whisper, as it has been indicated in the other cases, that this particular cancellation application has no application. May I be permitted to read that particular line, my lord, at least referring to one of the judgment?
No, read, but how it is going to improve your case?
Because, my lord, that is only with respect to the petitioner who is.
We are saying with respect to petitioner only now.
My lord,
The
my lord,
respondent.
because these two things are not in the record at the time of judgment at the 4/4/2000. That is why, my lord, we are before lordship.
No.
That is why we are before lordship.
No, that will not help you because that point is considered by various other tribunals.
Only with respect to that particular applicant.
Correct.
At the time of,
Therefore, with respect to this applicant only.
my lord, that is the reason, my lord, it is we have distinguished this particular case from the other cases. My lord, in respect of two cases were disposed of simultaneously, my lord. My
Very hair-splitting arguments.
No, my lord, I am making a submission why we preferred this particular read petition before lordship. Because once that particular observation is not there and it is staring at the applicant before the loan cat, the present opposite party, then in that case, a direction for consideration in his case is not permissible. Unless and until, at least my lord, he should have filed a review, my lord, before the loan cat, saying that that particular portion should have been added. It did.
The person who is successful in his litigation cannot maintain a review or appeal.
My lord, that particular portion is not there.
Even if it is not there.
Yes, ma'am.
The challenge, when we see section 19 of the Administrative Tribunals Act,
Yes, ma'am.
the cause of action is against the
Order.
action, order.
Yes, ma'am. Yes, ma'am.
So if that order is set aside,
No, that has not been set aside. That is why, ma'am.
under the order it is said, no, that makes, you can't interpret the tribunal's order like Great Court's order.
My
The
lord,
object of establishing tribunal you have seen in SP Sampath Kumar versus Union of India, L. Chandra Kumar versus Union of India.
right, sir.
The object is to substitute the High Court.
Yes.
Because the employee should get the relief, even if application is drawn on an ordinary paper. That is the object of tribunal. The object of tribunalization, the DK Basu versus so and so, so and so. The object of tribunalization is to make the procedure simple and the grant accessibility to easy justice. That is tribunalization. Otherwise, it will be writ court only. Although it exercises all the powers of the writ court, the constraints which writ courts ordinary will have, and much less the constraints of English courts.
My lord, my entire endeavor, my lord, before your lordship, only to just satisfy your lordship, only to that extent,
We are
that
not
what
satisfied.
prompted, what prompted us to file this writ petition. Because, my lord, we found that such a stipulation, as it is available in respect of other cases, my lord, that is not available in this case. So, once that particular cancellation is in force in respect of this particular applicant, then, my lord, a direction to consider his transfer, it is not possible on our part. And the second part, my lord, that with respect to the introduction of the new policy. These are the two things, my lord, for which, my lord, we approach before lordship.
With cost,
And
with cost. Dismissal with cost. Because same thing should not happen. See the audacity of your client. Your client has suffered plural orders at the hands of plural tribunals. And plural matters were carried to the High Court by your client. Various High Courts in the country said no. I am not satisfied. Your client went to the Supreme Court. Again suffered orders. And that is not so much. This case is very hot against this. No. This is a case where we have to impose cost.
But only,
We can
my lord,
argue
with
how much
respect,
we propose to impose a 1 lakh rupees cost.
but only
What
with,
do you want to say of that?
but only with respect to imposition of the cost, my lord, I am making this officer. That kindly visualize the situation of the authority to implement the order.
Why? What is the difficulty? So
Difficult-
simple.
My lord, that is what I am making submission. I think, my lord, I can
Now, if you
present it.
agree to implement the order, we will give an option to you that we will not impose the cost. Simply, you should say, we will implement this order in a time-bound way.
My lord, your lordship may order to that effect, my lord.
No,
By
the cost- we will not order. Once we order, 1 lakh rupees cost.
My lord, only with
We
your
cannot
lordship,
waste
only with,
time of the court.
my lord, with your lordship's permission, my lord. If there will be a clarification to that effect that this particular policy, as it has been done in other cases, my lord, will have no application to the present.
All that may not be necessary. This is all academic. They understand how you are going to interpret orders of
My
the
lord,
court. We cannot interpret the orders of the court keeping our common sense in cold storage, said the Supreme Court. Justice Dixit is only repeating what the apex court has said.
my lord, only one submission, my lord. With your lordship's permission, my lord. It is not actually, my lord, if my submission that it is not a frivolous application, only for the reason that, my lord,
It is.
only for the reason that, my lord, that once your lordship will clarify that, because, my lord, there are several X numbers of the persons, my lord, whose names are available in that particular list.
You leave them. Whoever is before the court.
My lord, that is what, my lord, I am making a submission. Your lordship may observe that, my lord, that will not have any application in respect of this petitioner. Once this will be done, my lord, there will be no difficulty on the part of the petitioner or this petitioner, my lord, to implement it.
No.
But once we will implement without any information, my lord.
Since you have argued so many points for almost 25 minutes. Sorry. Very important matter. This is not, you should not trouble.
My lord,
We argued very well.
No,
Because you have to argue, you are briefed to argue by, you are trying to understand. Panel let, okay? No. Therefore, ask them whether straightway they will implement this order or 1 lakh rupees cost.
with your lordship's only intelligence that this order will, that particular clarification will not.
Write an order.
My lord, that clarification will
Write
not.
it with a pen dipped in acid,
My lord, with
not
that,
in ink.
my lord, that,
Write it in with the pen dipped in acid. This is not the way the authority should do. They are not slaves. The employees of the union government, its entities, are not slaves. They are not slaves. They have status. You have seen, which is that famous judgment, 19 Tulsiram Patel versus Union of India. The employees of the government are not slaves. They enjoy status.
Yes.
From contract to status, they have moved now under the constitution. In fact, Justice Rama Joyce, a great judge, now he is no more, in his services under the state, has dedicated one whole paragraph for treating and lauding the judgment of Apex Court in Tulsiram Patel. In the first edition, 1984 edition, published by Indian Law Institute, to which Professor Upendra Bakshi has written introduction. Very readable book, one of the classics. Therefore, if you now you have argued, there is no option with us. We have to treat the submission.
then in that case, my lord, may I pray, my lord, because your lordship is giving an option, my lord, to implement it.
Yes.
With the lordship discretion, my lord, your lordship is giving me.
Straightway it should be implemented day after tomorrow. We will not waste time of the court. We will not waste time of the employee. See how long they have been fighting. I have so many employees. The kind of attitude of your client, though you are very humble, very articulate, very effective in your submission, that cannot, that under your shadow, your client cannot seek a refuse.
Because this matter will be taken on Monday, my lord. May I pray?
But you have, now you speak to our phone. If they agree, very well.
My lord, it is not the regional authority from the Bhubaneswar, my lord, that is the RD, because it is the head of the office, my lord, who is to take a decision.
But
may I
the
pray, my lord?
electromagnetic
No,
waves
that
with
today,
the same speed,
my lord,
whether it is
today,
to Bhubaneswar or to Delhi,
sorry,
they take seconds.
My lord,
But they move with 3 lakh kilometers per second.
because your lordship wants an order also, my lord. That is why, my lord, may I pray it for
We'll
Monday?
have it on Monday.
Yes, my lord. Your lordship kindly glance.
All right, Monday have it on. You reserve your argument on
Your
Monday.
lordship is content petitions.
Contempt don't precipitate contempt, because he is very fairly saying that he will do something on Monday. Matter was heard at length. First off, very effectively, that counsel appearing for the petitioners made his submissions. But we are yet to be convinced of the merits of the petition. First off, we suggested to the petitioners as to whether the implementation of the CAT orders can be wisely considered. First, at this stage, learned panel counsel seeks a short accommodation to confer with the client. Call on Monday. Till then, the content proceedings pending on the file of Cuttack CAT Cuttack shall not be precipitated.
May I pray, my lord? These
Yeah.
documents which I have already presented to the memo.
You can file in the court.
Yes, I'll do that.
To give back.
This matter also confirmed by the dismissed by the Honorable Apex Court, my lord. I have annexed, my lord.
We are aware.
Said.
We are aware.
We are aware. He himself said.
Same issue only.
It is there. It is there in the.
That is. Item 2, this contention you will not again repeat on Monday because you have already exhausted it today. Yes. Item 2.
Lord's item 2,
Yeah.
the appeal by the state. My lords, here is a case of premature retirement, my lords.
Premature retirement.
My lord. There was a review committee and they found that in public interest, the continuance of this person is
How
not
many years of service remaining?
5 years.
5 years. How many years he has put in service?
30 years.
After 30 years, he becomes deadwood.
My lords, your lordship kindly see para 4 of my appeal memo, my lords.
4 of appeal memo.
My lord.
He was 54 years, 7 months and 3 days.
32 years.
Complete with 32 years. 11 months. That is 33 years.
My lord.
You want to send him unceremoniously?
My lords, kindly see the letter, allegations.
That PS, what happened? Vigilance case, what happened?
That is pending.
Pending. Then how can
Two, my lords. Three times, my lords. In 2013, demanding, accepting ratification in world bonus, the 14 caught red-handed by vigilance team by being arrested, remained to jail custody. There is adverse remark in CCR from time to time. The review committee came to conclusion that
no, on the basis of act on which vigilance case is now structured, did you conduct any disciplinary inquiry?
disciplinary proceeding was initiated. That was stayed by the tribunal on the ground that vigilance case is.
Because identical matter, identical, same cases,
My lord.
same allegations. Palsamma Pal. Requires consideration.
Here, who has passed the order of termination? The SP has passed. I am the sub-inspector. SP has no jurisdiction. He has no authority to terminate this.
That
Who is appointing?
my lord.
And they have passed.
My lord.
You have said that you will answer that.
8.
Who is the competent authority
My lord,
to
sir.
compulsorily retire? Appointing authority.
My lords. Rule 825.
Rule 825
of the Orissa police rules. Officers empowered to impose punishments.
Just see the column.
C.
Officials, rank of the officials, appointing authority.
My lord, C, I am placing this. The superintendent may impose any of the police officers subordinate to whom and below the rank of reserve inspector or inspector any one or more of the punishments in Rule 824.
Well, it includes compulsory retirement.
My lords, dismissal, removal, compulsory retirement.
What the tribunal said on that? Learned single judge said on that.
And only one line, no finding on this. Only stated that the contention is this, is not.
Page 59, my lord, Impurnal.
Why 9?
Page 59, paragraph 25.
Paragraph
25.
My lords, it is further the superintendent of police is not the competent authority to pass the impugned order. This is what is concluded by the learned Honorable Single Judge.
Where it is said?
My lords, page 65. Page 65, just before para 38, 2-3 lines.
And your client was found red-handed, taking money.
That is a trap case, my lord. That is under trial.
Whether that pink test was conducted and it proved positive.
That has not discussed here, or nor I have.
Correct, because he's telling you there is another case which you got the stay of that. It requires consideration. You can't favor prima facie persons who are having grave allegations of corruption.
They have
admit and stay of impugned order in next date of the dispute. Yes.
My lord, may we fix of a short date
In the second week of March. Yes.
Item 3.
My lords, item 3.
Let me take you to this. Yes, 3.
My lords, seek adjournments.
2 weeks, the request of
My lord, this matter.
final. Next.
Item 4.
My lord, can I?
He wants time.
My lords,
On the last occasion, it was argued. My lord, I don't stand on your lordship's granting time. My lord, can it be on the next week? Because it's a case of appointment.
Let us see. 2 weeks is the request of Yoga. Yes.
My lord, a date may be fixed.
It will come, brother. It all depends upon if we say 2 weeks, we have already posted many matters. So one day, that
My lord, this matter was fixed to 4th yesterday, but it was not listed.
Suppose if it is not listed, you move a memo.
Obliged.
We remember.
Obliged.
Do that. Next.
Item 4.
May I please, your lordship? I am appealing through BC, your lordship.
Yes, sir.
Lordship, this matter has been infructuous, lordship. The petitioner already paid all the amount to the bank. And kindly forbid me to file the memo in course of the day, your lordship.
Concern for the petitioner submits that the relief having been granted by the authorities themselves, the petition has become infructuous and accordingly the same be disposed of. First of ordered accordingly and disposed of. Ordered accordingly. First.
Item 5.
May it please the court. Your lordship, the petitioner has filed a writ petition with a prayer against the opposite party number 2 to refund the transfer fee of rupees 2,77,000. The petitioner, who was a successful auction purchaser conducted by opposite party number 1, was dispossessed of his property.
Issue notice.
Obliged, your lordship.
Urgent notice. Okay.
Item 6.
Please, your lordship. This is the application, lordship. The petitioner filed the premature action of the bank before during the file of the OA for original application in DRT.
To seek application, you file application before the DRT seeking dismissal of the way.
That's the way. That is the way only. That is the also second lordship. What the illegal action is there? OA has been filed. Then after 13 notice.
That's all. On that ground, you seek that. Take up that contention. We are not issued. Who are you? Who are you?
Sorry. I am the standing counsel for EcoBank.
You don't stand there. Yes. Till we issue notice, you have no role to play. You have to stand just. Yes. Brother, we are asking you.
Assist you.
Even this course is open to the bank. That's what 2013 Supreme Court says. Even otherwise, you make that application before the tribunal. We'll keep all the contentions open. And we request the tribunal to consider that application.
Already have appeared. Matter posted to second appeal.
Have you filed application for dismissal?
No.
Then how court tribunal will know?
Second appeal matter transferred adjourned to second appeal to file the objection.
Therefore, along with the objection, you file application seeking dismissal. All right. Petition prayer reads as that.
Also only prayer till that today. Till today, that second April, anyway stay the matter in action of the
petition prayer reads as that. Learned counsel for the petitioner. You are a borrower? Yes. Petitioner, borrower, when Minty submits that. Once SA is filed before the DRT, it is not open to the bank.
Original application.
OA is filed before the DRT, it is not open to the bank to take any coercive measure in terms of section 13 or 14 of the Surface Act 2002. And therefore, the OA should be directed to be dismissed on that ground per se. Person. He also seeks stay of the said OA in the event. Stay of the said OA. First. Next. Having heard the net counsel for the petitioner and having perused the petition paper, we decline indulgence in the matter in as much as it is open to the petitioner who happens to be the opposing party in the OA to seek its dismissal by moving appropriate application. Person. That is the right remedy. Consistent with the category of decisions of Apex Court. Person. Where an alternate and effective remedy otherwise is available, the writ courts ordinarily would not entertain petitions of the kind. Petition of the kind. Person. Next one. In the above circumstances, the petition is rejected in limine with the observations here in above. Next.
Item 7.
No question action till second appeal.
Dismissing. Yes, next.
Item 7.
Lordship, limited prayer. I have a petition is availed 25 lakhs rupees of CC as well as the 15 lakhs of the.
You are the borrower?
Yeah, I am the borrower. Only.
There is a permit for this. When the loan was taken?
The loan was, it was sanctioned on dated 30/11/2023 due to death of my father, as well as coincidentally accident of my wife, as well as the mother is the bone marrow. So only I have regularized. My only
we are asking the question. When the loan was taken?
30/11/2023.
What is the amount?
CC amount, sanction amount, Your Lordship. Sanction amount, CC amount is, cash credit amount is 25 lakhs.
25 lakhs.
25 lakhs. As well as the term loan account, term loan is 15 lakhs.
15.
So as on dated, the entire outstanding is, as on 6/9/2025, Your Lordship.
Yes.
It was 37 lakhs 35,896 rupees and 06 paisa. My only humble submission to regularize the outstanding amount or whatever the overdue amount, I am interested to regularize the aforesaid loan account. Only my consideration or depend.
Did you make that representation?
Yes, I have. It is the annexure 6, running page 46, Your Lordship. Annexure 6, running page 46. Only my limited submission.
No, this has come after 13/4.
After 13/4, Your Lordship. Unfortunately, death of my mother, coincidentally accident of my wife, as well as that all documents also I have annexed.
Possession has been taken.
No, your symbolic possession. Only symbolic possession.
So symbolic possession taken.
Only symbolic possession is taken on dated 29/11/2025.
That has happened. That accident happened which date?
My lord?
Accident happened which day?
My lord, father was dead on dated 4/3/2025 and wife is accident, Your Lordship, running page annexure 4, running page 23, Your Lordship.
But possession was taken when?
Possession is taken, symbolic possession was taken 29/11/2025. And
After death.
3 years mother is bone marrow, till admitted hospital. That all documents I have annexed, Your Lordship.
Heard learned counsel appearing for the petitioner borrowers. First up, a case is made out for issuance of the emergent notice. First up, issue emergent notice. Returnable within 2 weeks. Let it come within 2 weeks.
Only oblige, Your Lordship. Till then, no question.
Counsel for the petitioner draws attention of the court to application in IN number 173/2026, which is supported by an affidavit seeking filed for seeking interim protection.
IA 173 of 2000.
Yes, yes.
Yeah, 173.
Pardon.
Council submits that there is a bereavement in the family because of vehicular accident that took place on 4/3/2025. Petitioner's wife has also suffered grievous injuries in
Accident.
Petitioner's mother is cancer.
Mother is
Wife dead.
wife is accident
But-
and father is dead.
suffered grievous. Mother is undergoing bone marrow related medical treatment. First time. He submits that if no interim protection is afforded, the family, the petitioner will be put to enormous hardship coupled with equal amount of injustice. First, there is foreseen this submission. Prima facie. First, in the above circumstances, next paragraph, application having been favored, the respondent, opponent, OP bank is restrained from processing any coercive action till next date of hearing. First, since this order is issued ex parte, it is open to the bank to seek rescinding of this order if grounds do exist thereupon.
Item 8.
Yeah,
Petitioner herein is one of the allottee.
one of the allottees.
Manoj.
Say it now.
One of the allottees.
Allottees, yes.
The opposite party bank was the project financer, and opposite OP2 is the promoter. Herein the bank had financed the entire project. Now, wherein the petitioner, who was given an allotment for a flat in Barampur, a place, there was no construction of the flats. The construction was delayed, and the petitioner number 2, he fled away from the jurisdiction of the state, and CBI crime branch investigation happened, and he was also apprehended. Charge sheet was filed, and now also he has absconded after he was enlarged on bail. The OP1 bank had initiated recovery measures against the petitioner and several others like the petitioner by filing suit before the Lanet DRT. And Lanet DRT, the suit was filed with the pecuniary jurisdiction. Now, the pecuniary jurisdiction of the Lanet DRT, while the time of filing of the suit was more than rupees 20 lakhs. That is page 66, which is the Gazette notification, which says that the pecuniary limit to initiate a suit before the Lanet DRT would be equal, not less than equal to rupees 20 lakhs. Now, the opposite party bank proceeded to initiate a suit against me with an outstanding of rupees 16 lakh. And at the time, the Lanet DRT did not have the jurisdiction to entertain the said suit, had entertained the same. So one of my prayer is that Lanet DRT is lacking the inherent jurisdiction to entertain this suit.
Inherent jurisdiction.
Well,
suppose if DRT takes up a cause which is more valuable than what is prescribed, it is without jurisdiction. It falls into pecuniary jurisdiction.
Pecuniary jurisdiction.
Is it not? But if a court has higher jurisdiction, but lower monetary value claim is put forward, can it be a case of inherent lack of jurisdiction?
Pecuniary jurisdiction.
Where is the lack of pecuniary jurisdiction?
Well, it's because the notification itself
gives a higher monetary value.
It starts like
25 lakhs.
20 lakhs.
Correct.
20
It
lakhs.
is less than that.
So the notification says, Malaj, may I just please at page 66. Whereas the central government has considered it necessary to raise the pecuniary limit from 10 lakh.
It has been raised from 10 to 20.
Now, therefore,
it has no jurisdiction.
Well, I'm on the pecuniary limits of the DRT.
You are not on the pecuniary limits, sir. You are within the pecuniary limits only.
What they say, the central government here specify the provisions of the said act shall not apply where the amount of debt due to any bank or financial institution or consortium of bank or financial institution is less than 20 lakh rupees.
Act itself will not apply. But it is not pecuniary jurisdiction. It is a case of non-application of the act itself. They stand on different footings. The jurisdictional aspects are discussed by the three-judge bench of the Supreme Court in 1954 SC, Kiran Singh versus Chaman Paswan. Let's we just look into that. Now we'll issue notice also. One, could you not seek dismissal of OA before the DRT? On this application. Make an application.
Well, sir, since I had made 2-3 other prayers also.
What are the other prayers?
The other prayers are since we have been paying the interest amount and the because the entire disbursement was made to the. So I had also made 2-3 other prayers. One is to direct the bank to remove my name from the to declare me as a non-defaulter and to rectify the CIBIL scores.
For that, ombudsman is there.
The Credit Information Companies Act is there under the RBI. So their section, I think 18-20 stipulates that
you can approach.
Yes, and the CIBIL itself, they can remove it on the recommendation of the financial institutions.
No, at this point, you want to appear for the bank?
I'm appearing for the bank. He can move an application for the DRT, Miller, too. Because DRT is.
You will do that, but on that ground, you cannot. You will non-suit him here very well. But till he moves an application within the period which we are now prescribing, we are not supposed to process the matter.
No, Miller. The DRT, the date of publication, we have to see the date of filing in the DRT, the date of publication. Then only it operates. Well, the notification came probably in July 2019.
July 2019.
6/9/2018.
No, that was the notification, but it was
effective from?
The gazette notification, we have to see that before that, the OA was maintainable. So the dates we have to check it. If survey copy to me, comment 2 days after.
So the notification is that is 1st August 2019. It came into force, my lord.
1/8/2019.
1/8/2019.
When the suit was filed?
The suit was filed on 19/3/2019.
So before that.
2019.
Then it is within the period.
Yes.
The notification, I am placing page 66. Page 66 of my brief.
No, thereafter another notification has been issued on 1st August 2019.
This is
I have that notification.
6 September 2018.
But this petition you can make before the DRT.
Yes.
The court which has jurisdiction has jurisdiction to decide whether it has jurisdiction or not.
It is the same court to decide.
That was the thing which I doctrine of competence and
No. You make that application. They will consider. Bank also will have opportunity. We will tell them you file application within 2 weeks, and till a call is taken on the said application, that DRT shall not process the matter.
Otherwise, how he will move an application, Miller?
Therefore,
the surface proceeding that we are going to take possession. It's a DRT recovery suit. So if DRT cannot move, let him file an application within 7 days.
That's what.
Yes.
And there is no threat to him. Miller.
No, there is threat because I have been paying the amount and they are now processing with the surface action against the other. That's what I'd also.
What surface
there?
No, surface action against me.
Against you, they are taking.
They're taking.
You move application before the DRT now, seeking dismissal of this suit. All right. Petition prayer reads as well. Next, learned counsel for the petitioner, pressing into service petition of Apex Court in Kiran Singh versus Chaman Paswan, AR 1954 SC 340, submits that in view of the amendment to the Surface Act,
to the debt recovery of debts. Recovery of debts due to banks and financial institutions.
So, by virtue of notification dated
6 September 2018.
September 2018, the DRT lacks pecuniary jurisdiction And also that the act itself is not made applicable where the monetary claim in the suit is less than 20 lakhs, 20 lakh, rupees 20 lakh. First. Learned counsel Shri, panel counsel Shri so-and-so, representing the bank, opposes the petition, contending that the prayer which the petitioner has made here can be put before the DRT and without exhausting that remedy, writ petition is ordinarily not entertained. First, next, having heard learned counsel for the party and having proved with the petition papers, we decline indulgence in the matter, broadly agreeing with the submission of learned panel counsel appearing for the bank. First, next paragraph. The above being said, since the petitioner is being non-suited on the ground of availability of alternate remedy, liberty is reserved to him to make appropriate application before the DRT, seeking dismissal of the suit on the ground stated. First, that he has to do within a period of 10 days. First, if done, no coercive action shall be taken against the petitioner under the pending suit till the decision is taken on such contemplated application. In that connection, all contentions are kept open to both the sides.
Lord, my submission is that the notification came after the filing of the suit.
We can take up that contention in the above circumstances. Petition circumstances and with the above observations, petition is disposed of.
Item 9.
Let's see, in this case, the present petitioner's son was studying abroad at Edinburgh University, in the Harriet University, Edinburgh, United Kingdom, Your Lordship. The loan amount is, educational loan amount is sanctioned on dated 31st
Edinburgh University.
Harriet University. Harriet University, Edinburgh campus.
Okay.
United Kingdom. But unfortunately, Your Lordship, loan is sanctioned 37 lakhs.
Education loan.
Oblige, Your Lordship. Educational.
When it was?
It was on 31st December 2021, Your Lordship. Only the 31st December 2021, Your Lordship.
Loan is 37 lakh.
39 lakhs 52,000. But only 3 lakhs 73,680 is transfer to the university.
This is sanctioned loan.
This is loan sanctioned amount.
This is a small amount.
So disbursed amount is, debit transfer amount is
3
lakhs 73,680. Transferred to the university. In the meantime, Your Lordship, due to COVID-19 adverse situation, so university not provided the visa as well as admission is not take place for the computer science courses. So in the meantime, 13(2) notice is issued on dated.
What is the amount due?
Amount due is that is 4,67,043. 4,67,043 as on 16/10/2025. So my only humble submission to consider my OTS representation because amount is transferred to the university. It is not transferred to me. It is direct debit transfer. Kindly have a glance, Your Lordship.
Suppose if you tell the bank
Yes, my lord,
No, one second, listen to us.
my lord,
On law,
my lord. I have approached. I have approached on.
Yeah, 1 second. You go to the bank
My lord.
and tell them that I want 50 lakhs, 50 lakh rupees
My lord.
to throw in Mahanadi River. And you are furnishing security for that.
Yes.
Bank will give that money to you. Can you say they have direct and you have told remit this money to the Edinburgh University. Bank did not do it on its own.
No.
Therefore,
it was an admission brochure was
on your instruction, bank has sent it.
Yes, yes.
How can you take the advantage?
No, my lord. Due to adverse COVID-19 situation, that's why admission
is
is
a ground for granting time. But it's not a ground for reducing the amount payable. What are you? What are you doing?
So my only humble submission.
What are you doing right now?
Now, ultimately, I have continuing at Haryana University. I have continuing BTech.
All right. What is the father doing?
My father is a bedridden patient, and his property is.
Where are you staying?
My lord. His property is mortgaged on annexed.
Then they will go against the property.
My lord, my only limited prayer to consider my application annexure 5.
You approach a bank.
So that I have approached.
Where is the duty on the part of the bank?
That I have
consider your application for OTS. Where is which is the rule?
That is the 23/12/2025.
No, what is the rule to consider your OTS? Under which scheme?
Under which scheme? Tomorrow everybody will come to.
My lord, this is a specific unavoidable circumstance.
No,
due to COVID-19 adverse situation, I am unable to study abroad. Honestly speaking.
But what can be done?
Bank is also reimbursed that amount to the university.
Correct. Because you told it.
Because I have given that admission letter, that's why it is transferred. Rest amount cannot be transferred during COVID-19 adverse situation. My only submission, my only prayer, only dwelling house of me, undivided joint family, to consider my application, OTS application annexure 5.
Give the OTS.
That is annexure 5, running page 36, your lordship.
OTS scheme.
OTS application.
Representation.
OTS representation. So till it is not, no decision has been taken by the bank.
Where is the duty to take a decision? You have to show to the rich court that bank is under a legal duty to consider your request for restructuring of the loan, reduction of the loan, waiving of the interest. Unless this is how Tennant on banking law says. The famous book, Tennant on banking law, says that in the absence of a duty, no court can direct the bank to give concession. They will ask, how? Judges, what? We will become the bankers.
My lord,
we are not doing that.
My lord, from the bank statement also, on the annexure
you don't disbelieve you, sir.
So
we are only asking
we have deposited till 18/9/2025. I have also deposited.
Yes. Next. Item 10.
Till then, no.
Nothing.
Obliged.
Item 10, I may be permitted through VC, my lords.
Item 10.
Item 10, I am a permitted, my lords. Am I audible, my lords?
Yes, audible and visible also.
My lords, a limited prayer of the petitioner is that the petitioner being the borrower.
Of essay.
My lords, early disposal of essay, your lordship, my lords. That is pending since 26/12/2023, my lords. More than 2 years have passed, my lords.
Petition prayer reads as under. Learned counsel for the petitioner submits that right to speedy remedy is a facet of Article 21 of the Constitution of India, and therefore the long pendency of his essay number 236 of 2023 on the file of the DRT Cuttack militates against this right. First, we broadly agree. Next paragraph. Notice to other side is dispensed with since no coercive order is being made against them. First, even otherwise, they can seek recall of this order if grounds do exist therefore. Yeah. First, next one. In the above circumstances, petition is disposed of, requesting the presiding officer of the DRT Cuttack to hear and dispose of the subject essay as early as possible, and in accordance with law. Ordered accordingly, and petition is disposed of. Yes, please.
My lords, some time limit may can be.
What is the workload there? You give entire statistical data. So many cases are pending, and the DRT judge is capable of deciding this case. Therefore, we can only say, now you have seen the petition.
Maybe 6 months. Maybe 6 months time, maybe, my lords.
Yes.
Item 11.
Registry to send a copy of this order to the OPs, but by speed post immediately. Yes.
Lord, I'm checking the disposal of Section 14 application. Your Lordship has dealt with similar matters.
Bank of India. It's a moment. More than one paragraph we just add here.
11, 12, both members.
No. I'll put it in low mark. Notice to other side is distance later. Since the prayer is not yours, and we are not making any positive direction on merits of the matter.
11 and 12, both.
11, 12, both.
11.
Obliged, thanks.
Item 13.
Where please be notes. Petitioner Lord is a successful auction purchaser, and,
Yes,
a,
Mr. Khan.
and a sale certificate has also been issued to him, right? Annexure 1 series minutes in respect of 2 properties.
You take possession, you take a notice, emergent notice.
Here, the bank says, when I approach the bank says that we have deposited the requisite amount of money with the police authority since 2025. That's Annexure 3.
So you take emergent notice. Learned issue emergent notice. Learned AG is requested to accept notice for OP numbers 1, 2, 3, 4. 1, 2, 3, 4. First stop. Emergent notice to the rest. Returnable within 3 weeks. Yes.
Much obliged.
Appealing for this petition.
Greatly obliged.
Okay.
Item 14.
Yes.
In this case, my lord, the petitioner availed house building loan by 20 lakhs by the year 2014.
You make representation to the banker.
Already made a repair. So lordship, I'll see also 5 by page 33. This is
You pay for the bank. You consider the representation.
My lord, this is first time. Let us
Anyway, that's what. Therefore, we are telling you. Otherwise, in your absence, we will make the direct the bank to take a call on the application.
in the meantime, my lord, bank has issued notice for sale by now.
You
Except 28 2 by now. So in the meantime, repairs may be considered.
No, we don't have that power at all. If you say, we will direct the bank to consider the representation.
My lord,
That's all. If you press more for that, we will dismiss the petition.
No, my
because we have no jurisdiction.
Your lordship.
Petition prayer reads as that. That's learned counsel appearing for the petitioner, giving up the same prayer, very fairly submits that if a direction is issued to the OP bank to take a call of the representation dated.
Representation date not given about pleader notice date is 16/1/26.
You have given the notice.
I have given pleader notice, but a representation no date is there.
Representation stroke legal notice dated
16/1/26.
In a time boundary and in accordance to law, the client will be satisfied. First up. Learned panel counsel Shri.
My lord, I'm My single.
Do not.
Right, so, on request appearing for the, voluntarily appearing for the bank, although initially opposed to the petition, now very fairly submits that a reasonable time be granted and all contentions be kept open so that consideration of the subject representation takes place at the hand of the bank. First, this is appreciable. Next one, in the above circumstances, the petition is disposed of, directing the OP bank to consider the subject representation stroke legal notice within a period of 3 weeks. Within a period of 3 weeks, and inform result of such consideration to the petitioner within 1 week next following. First, all contentions are kept open. Next.
Till that date, no coercive action by law.
Next.
No coercive action is lordship otherwise, unless it is protected by lordship. No coercive action otherwise. Urgent copy.
May I please?
Yes.
I'm seeking a liberty to approach with the uploaded forum before the DRT.
You will appear before the DRT.
My lord. Already sale notice has been issued.
OTS application. It is already disposed of.
My lord.
Rejected. Petition prayer reads as under. Next one. Learned counsel appearing for the petitioner submits that since already the OTS application is negatived by the bank, petition may be disposed of, preserving liberty to him to take appropriate proceedings against the same in accordance with law. First, prayer is innocuous. First, next one. In the above circumstances, petition is disposed of with liberty as sought for. First of all contentions of the party kept open. Yes, we'll just need to send copy of the order to the bank, to the office. Yes.
Item 16.
Lordship, item 16 praying for pass.
Pass.
Item 17.
Please, Lordship.
Yes.
Lordships, the petitioner is a MSME, my
Lordships, in item 17, I'm appearing for opposite party number 1 on caveat. I seek a pass over, your Lordships.
Pass.
Item 18.
My plead, Lordship. In this case, petitioner filed this case by challenging the notice dated 22/1/2026 under an
notice.
auction notice.
Auction notice.
Auction notice that is going to be held on 6th February 2026. But in the meantime, petitioner already approached to London DRT. But under Annexure 13, there is presiding officer is not available on the DRT. So
why is not available?
He is remain in leave. I annexed the said notice.
How long he is on leave?
Notice is published.
No, how long he has been on leave?
To 2026 to 5 to 2026.
Yes, today he has come back.
No, next working day is fixed for 9 February. My auction is scheduled to be held
tomorrow.
6 February, tomorrow.
Tomorrow it will happen, and you will seek relief at the hands of the DRT. Shorn of the long prayers made in the petition, the grievance of the petitioner is against you for the bank.
And for the bank, since 2024, he was given by this Honorable Court the direction to approach the DRT. This is the fourth petition filed by the petitioner.
Why, brother?
Petitioner is so poor.
You could have told your client to pay the fee without paying the filing the
petitioner is also ready for the pay 30% of the loan amount.
Well, that they will not be happy. They want full money.
Starting from Oh.
Shorn, SHORN. Yeah. Grievance of the petitioner is essentially against the public auction scheduled to be held tomorrow. Scheduled to be held tomorrow. Tomorrow. First one, he submits that the client is ready and willing to pay 30% of the amount, and therefore the auction should be held. First one. Learned panel counsel appearing for the OP Bank vehemently opposes the petition, pointing out that petitioner was before this court earlier in WPC number 31207 of 2024, which came to be disposed of by a coordinate bench of this court, wide order dated 16/12/2024, reserving liberty to him to file appeal before the DRT.
Thereafter, he approached for WPC 14339.
Subsequently, petitioner approached this court again in WPC number
14339. I'm given the copy.
And so, which also came to be disposed of by another coordinate bench, wide order dated 16/5/2025.
Thereafter, another petition is 37214 of 2025.
First up. Relentless, petitioner filed at another petition, filed at another case in WPC number
37214 of 2025. The copy given.
Which came to be disposed of
24th December.
by another coordinate bench, wide order dated 24/12/2025. In all these petitions, liberty was reserved to the petitioner to approach the DRT. First of all, that being the position, how the petitioner can move at another petition remains to be a mystery, wrapped in enigma. First of all, this case borders abuse of process of the court. First one, so contending, the panel counsel seeks dismissal of the writ petition. Next one, having heard the counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the submission made on by the panel counsel appearing for the bank. First one, filing petition after petition is not a good thing to happen in a writ jurisdiction, in as much of public resources would be wasted in treating the same. First, in the above circumstances, petition is dismissed.
The auction notice is tomorrow going to be held. I also already approached to DRT.
Next.
That is pending before the DRT.
19.
Your my lord, I am appearing for the respondent number 1. This is a covered matter. Here my area has been restricted prior to filing of the writ petition, because the writ petition was disposed of on 29/6/2025 for 3 years. And on the basis of the judgment of the Honorable Appellate Court in the case of RCMC, and your lordship have decided already.
Covered by judgment.
Covered.
But at that point of time, that's keeping in view that
I think in this you only appear.
Number of cases have been disposed of, and all are implemented.
the delay is there, my lord.
Your lordship may condone the delay.
This appeal by the state and its officials calls in question, a learned single judge's order dated
35
30 May 2024, whereby respondents WPC number 13724 of 2024 having been favored, the following relief has been accorded in terms of paragraph 7. Next paragraph. Learned counsel appearing for the learned AG appearing for the appellant submits that the impugned order suffers from various infirmities and therefore matter requires for examination. First, learned counsel representing the
Respondent number 1.
First respondent employee opposes the appeal. Pressing into service, and the order of a coordinate bench of this court in writ appeal number 3222 of 2023 between State of Odisha and another versus Debendranath Mishra, disposed of by order dated 17/7/2025. First up, he tells us that the subject matter of the appeal is squarely covered by this cognate decision, and therefore the present appeal is liable to be dismissed. The same is liable to be dismissed. First up. Next paragraph. On perusal of the order of the coordinate bench in Debendranath Mishra, we are convinced that the submission of learned counsel representing the first respondent is absolutely true. First up, there being no derogatory circumstance, the case of the appellants is to be treated on the principle of verity, qua the decision in Debendranath Mishra. First up, in the above circumstances, treated on par with Debendranath Mishra. In the above circumstances, the appeal being devoid of merits is liable to be rejected, and accordingly it is what's having been made easy. The order of the learned single judge, what we have said about that?
35/2000.
Item 20. Item 20 is a state appeal.
Yeah.
Having the delay of 163 days.
Sir.
Yes.
Item 21.
20 minutes, sir.
20.
Yes, 20 minutes.
Delay.
Just minutes, sir. I am appearing, my lord, the copy of the appeal memo be served to me. Let it come next week, my lord, because the petition is not getting up. I responded is not getting the pension.
My lord, may I pray, my lord? They have initiated the content proceeding. It is fixed to tomorrow.
Tomorrow, my lord,
that is fixed to tomorrow, my lord.
Don't precipitate the contempt matter.
Yes, because, my lord, they have already specifically directed to provisionally calculate, my lord. May I pray, my lord, one thing, my lord. Let a copy of the appeal memo be served to me.
That in course
will be taken up next week, my lord.
After 2 weeks. In the meanwhile, the contempt proceedings in respect of impugned order of the learned single judge may not be processed.
The date
processed.
My lord, order dated 6 September 2020.
6/12/25.
6 September.
6 September 25.
The date made fixed, my lord.
24.
24.
24. All right.
The date made fixed, well, because
2 weeks it will come. Yeah.
Item 21.
My lord, appellant is a cooperative bank, my lord. The respondent has misappropriated more than 14 lakhs. 14 lakhs, 11,602 rupees, my lord.
You are for whom?
I am cooperative bank, now appellant. My lord, my lord, honorable single judge passed order in absent of the appellant, my lord. My respectfully submission, although the advocate has been engaged, but the advocate did not appear before the honorable single judge and not filed a counter for which the case was decided in absent of the counsel of the appellant.
I am for the respondent, my lord. That is wrong submission. On 25/6/24, the appeal took time to file counter. Then on 25/7 to 24, my lord, they appeared and took time for filing counter, my lord. And they only on basis of an audit report with no inquiry is made. I retired since 2018. 30th August 2018. Not
No, my lord.
pension.
Surcharge case pending, vigilance case pending. My lord, that is pending before the authority. The bank has no role to dispose of the matter. The vigilance court has not decided the matter, and also SP surcharge proceeding case is also pending, my lord. More than 14 lakhs, my lord, pending against the respondent, my lord.
Did you disclose the surplus proceedings and
only on the basis of an audit report, my lord?
No.
We are asking you.
I have annexed.
Good.
Yes, ma'am.
Quite. We are asking you.
Yes, ma'am.
In your petition.
Yes, but petition and writ petition.
Did you disclose surcharge proceedings pending against you?
Yes, ma'am. In paragraph 7, my lord, of the writ petition.
And the criminal case?
Yes, I have disclosed, my lord. Paragraph 7 of the writ petition, my lord. They have rejected my claim.
I see. What was he?
The banking assistant.
Banking assistant.
Assistant. As a deputed posted in the co-president.
Where have you stated the pendency of the surcharge proceedings and criminal proceedings?
Paragraph 7.
7.
Yes, they have rejected your two counts, my lord.
Stated about, we are, question is very clear.
Yes, ma'am.
Where have you mentioned about these two?
Pendency of these surcharge proceedings you have not mentioned.
Surcharge
Pendency of the criminal case you have not mentioned.
Yes, I have mentioned, my lord.
Where?
Vigilance case number registered against the petitioner.
Yes, my lord. I have, in page 23, my lord, the third, in paragraph 7, I have
for the direction of the deputy.
the third plea ground regarding pending of vigilance case is not sustainable since the vigilance case number registered against the petitioner on 27/12/2018, much after the date of retirement, until today no charge sheet has been filed. That is
No, that makes no difference. Charge sheet is not filed in that.
now on the date of retirement, on 30th August 2000, there was no proceeding, my lord.
You retired when?
On August 2018.
No. August
2018. On the date of retirement, there was
no, my lord, 14.
18. 2018 retirement.
18.
On August 2018, on the date of retirement, there was no proceeding, my lord.
18.
Those proceedings were initiated after my retirement, my lord.
After retirement means after how many days? How many months? Your law provides, your Cooperative Society Act and rules provide.
Yes, that may be.
Within 4 years.
That cannot be recovered from gratuity, my lord. I am only for gratuity and leave salary. That cannot be recovered because after on the date of retirement there was no proceeding. That cannot be recovered from gratuity, my lord. I am only paying my gratuity and leave salary may be released, my lord. That is
his retirement benefit. Other benefit is
not entitled.
Not entitled to. There is no pension scheme.
No, where is the learned single judge has not treated the contention, even as on the petition, whether they file objections or not, counter or not. There is a vigilance case pending against you. There is a surcharge proceeding pending against you. Though you have said about them, the learned single judge has not uttered one single sentence about that.
Non single judge only says since I am retired and on the date of
said that. Cannot be like that. Pensioner should be, retired people should be protected, is true.
Yes, ma'am.
But those who are not tainted,
that's on the
criminal case is pending. Now you say charge sheet is filed. You said that.
Criminal case on the date of retirement.
That you have said already. But now
on the
charge sheet is filed under 173 of CRPC. After the
that is subsequent, my lord.
That's true.
That is subsequent, and that will on my on the date of retirement. I am entitled for gratuity. I am only paid for gratuity, my lord.
No, the matter requires consideration because there is no other terminal benefits. No pension, nothing to you. Only gratuity. No recovery can be made from the gratuity.
Gratuity cannot.
Yes.
No,
Gratuity under the
on the
Gratuity Act, yes. But if gratuity is payable under the service rules.
Yes, madam. My gratuity can be recovered only when there is a proceeding pending on the date of retirement, not after that, my lord.
There was surcharge proceeding pending.
Surcharge proceeding subsequent, my lord.
Three surcharge proceeding.
When they were
that can be recovered.
Why did you not file your counter before the learned single judge? Why are you telling all the pocket book stories here?
My lord, the conducting council.
You take action against him. Write something against him to the bar council. But changing the advocate will not add merit to the case of the
my lord.
No, nothing can be done. You are a cooperative society.
Yes, cooperative bank society registered under Odisha Cooperative Society Act.
So you should have been very vigilant. You had taken time twice.
Well, there are 9 dates.
The counter.
9 dates, my lord.
9 days.
9 dates.
And you had not filed any counter. Now you are saying this is pending, that is pending, this should happen, that should not happen. How we can treat? Where is the contention available to be treated by us when it is not treated by the learned single judge because of fewer lapse? Paid it 25,000 rupees now as cost to the advocates welfare fund. Then we will consider.
My lord,
yes, sir.
Public money involved in this.
Therefore, you should pay it from the pockets of your office bearers. Save public money. Shell out private money. They are members of the office bearers of the bank, na?
Management.
Yes, management. Whatever benefit they will derive, let them share it.
No benefit, my lord.
We don't know. But why they will continue to be members of the board? Without benefit.
He has engaged an advocate, my lord. Advocate has not intimated.
If you see, we do not know. So now, have you taken up that contention in the appeal?
Yes.
I have. Advocate did not intimate. How you came to know?
When you wanted his name is recorded, my lord.
No. I was not advocate in that case.
But your name appears.
No.
Order.
Perhaps you stated that I am penal advocate. No, I have not. I have not engaged in this case.
You should go to the court and tell.
No,
written wrongly that I am not the panel counsel. Otherwise, you continue to be panel counsel.
এটা ভুল মেনশন এই দেখেন
প্রথম অর্ডার দেখি কোনটা আপনি না লাগাই
I was not conducting. No. My lord, LCR is available. LCR is available. My lord, Peru is the LCR. Whether my name, my Bhakalatama has been filed. No. No. Bhakalatama available in the court record.
No, question is, on Vakalatnama you appear. But sometimes courts have power.
No, my lord. I have never appeared in this case.
Correct. But there is an order. You should have gone and told the court. No, you are mentioning our name. I am not appearing. Therefore, unless otherwise you ask fees from the court itself. They will not pay. Pay fees, I will appear.
If honorable court directed me to appear, I may intimate my client. This is order sheet. My lord, record is available.
Ashok Kumar Ratna.
Ashok Kumar Ratna. Yes.
And DR Mohanty.
Yes. Who kind information?
Whatever they have, checking from force order, my lord.
You know, I was not conducting advocate.
That is not absolve you are eminent to bar counsel.
My lord, one opportunity may be given to heard the matter before the not only single judge.
Why? What we are doing? We are doing that only. Only to satisfy you, can we remand the matter? What others will think, those who have been seeing us.
Your lordship may pass order.
You deposit 25,000 in the registry first to show bona fide.
25,000 is it?
How much then?
5,000.
5,000?
Yes.
What will come for 5,000 in Cuttack market?
Cooperative organization very small, my lord.
Go pay 10,000.
Bank.
10,000 rupees. Issue. I heard learned the panel counsel so and so appealing for the cooperative, the current cooperative bank. First of all, there is a delay of how many days?
Delay is there.
Delay 81 days delay, my lord.
An application is, the appeal is filed, calling in question. The single judge is already filed, so there is a short delay of 81 days.
42 days.
42 days. Is proved in filing the appeal to first time. An application supported by affidavit accompanies the appeal memo seeking its condemnation. First time. Counsel for the appellant is right in telling us that delay is short and there is a plausible explanation that part. First, no prejudice will be caused to the other side if delay is controlled, subject to condition. In the above circumstances, application is favored and delay is condoned, subject to petitioner paying a sum of rupees 10,000 to the respondent employee who has since retired from service. Next paragraph. Another application is filed. Stay you have sought for?
Yes, my lord, contempt petition pending.
IA number so and so supported by affidavit seeking stay of the impugned order. First, the learned counsel for the appellant submits that already the impugned order is put in contempt case number so and so
1987 of 2025.
pending on the file of learned single judge who authored the same learned single judge of this court. First of all, if impugned order is not stayed, counsel says that the plaintiff would be put to a manifest injustice and hardship as well. First of all, we agree with this. Next paragraph. In the above circumstances, this application having been favored, the impugned order is hereby stayed till next date of stay until further orders. If the amount mentioned above is not handed to the respondent within 2 weeks, the appeal runs the risk of dismissal on that ground itself. In few minutes we are coming.
That is shortage of postal stamp, but notice conduct issue. You not see manla.
It's 3 days. 3 working days.
Yes.
Yes.
Item 23.
Yes. State's appeal.
Yes. 23 is a state's appeal, Milon. It's challenging the order passed by the Hon'Ble Single Judge dated 4th March 2025. Milon. Here, my lord, the question is regarding appointment of a Shiksha Sahib. In pursuance to the advertisement of 2014, there was a advertisement for appointment of Shiksha Sahib. There in 2 things are there. So for the qualification, that is BABD, and so far the age is concerned, that was 35. For upper age relaxation, it was 5 years.
He does not fit into that.
No.
Yeah.
So subsequently, some of the candidates, they have preferred writ application before this Hon'Ble Court. Considering the same, age was relaxed up to 35 to 42 million.
Relaxation happened.
Yes.
For all
by
the-
virtue of the, for all.
Not SC, ST, SCBC.
No, that was 5.
For all.
For all.
Relaxed by
5 years.
5 years.
5 years.
35 to 42.
35 to 42 million.
7 years.
7 years.
7 years.
7 years. And the last date was fixed to 28 to 2016.
Last date for?
And by
Method
the,
of application.
and after the order of this Hon'Ble Court, after order of this Hon'Ble Court, there was issued a corrigendum. It was on 9/2/2016.
For?
Making the application.
Refixing the date.
Refixing the date.
That is refixing the date at 28 February 2015.
16.
9/2/2016.
2016.
Yes.
Therein, Miller, kind of a glance to that corrigendum. It is at page 71 for a moment. This is at Annexure 6.
Is 44.
No, 71.
It's 71.
9/2/2016.
Annexure 6. May I read it, Miller? At the last. Candidate those who have come under the age group of 38 to 42 with such relaxation can only be eligible to apply afresh.
5 years relaxation.
Yes.
Yeah.
No, Miller, 35
for
to
the
42.
candidates between this age group.
Yes.
32, it ranges between 5 to 7 years.
5 to 7 years.
It's a
35
range
to 40 years.
Yes.
Yes.
Then it became 42. And the candidate, those who have come under the age group of 35 to 42 by virtue of the court's order, with such relaxation can only be eligible to apply afresh who had not applied for the post of Shiksha Sahib due to overage in response to the above advertisement. It pertains to the advertisement of 2014.
Candidates who come under the age group of 35-42 eligible to apply afresh who had not applied for the post of Shiksha Sahib earlier.
There is
overage.
Because by the time of advertisement,
They were
the
already-
person those who have been overaged,
For them,
after
this benefit is
that benefit. Others need not apply because other conditions remain intact. That is the specification given in this corrigendum. Madam, can you have a glance to next page? 72. The other, the calendar, the last date of receipt of such online application is 22/2016. The other terms and conditions in the above advertisement
unchanged.
remain unchanged, only in respect of this
Age
relaxation.
Yeah.
Well, so far the present petitioner is concerned, by the date of 2014, the last date, she was not acquired the BD qualification and it has been required as per the advertisement.
As on which date?
2014, Mila.
What it said? The application said the qualification should be what? What qualification?
BA BD, Mila.
BD. You mean to say for qualification, the cutoff date of original notification
First
applied?
advertisement.
The
Second one in respect of only relaxation of age. That is this reason.
How courts have answered?
Yes.
Any other court?
Well, the court, the Honorable Single Judge has
No,
answered.
that is put in Chalin. No?
Yes.
Any other High Court has taken the view?
Yes,
that
yes. Punjab High Court. My lord, may kindly see. Our own High Court.
When age relaxation is given by a supplemental notification.
Our own High Court.
No, you should permit us to articulate.
Yes.
Where age relaxation is given by a separate notification issued subsequent to advertisement.
Yes.
The qualification prescribed under the original advertisement.
Yes.
As to the date on which they ought to have been acquired.
Yes.
That also stands relaxed.
Yes. That is
how the qualification reads in the original
advertisement.
Original advertisement is BA. Your Lordship may kindly see
page 34
page
for a
35.
moment.
Page 35, the original advertisement.
Starts from page 34. 34.
We see for the benefit of those who were age barred.
Yes.
By the time of
others at all.
Yes, that's absolutely correct. Absolutely correct. But here the question is, since the petitioner was age barred, she applied for the post of Sikha Sahayak pursuant to the corrigendum, the second advertisement. That is not the advertisement, that is the corrigendum, fixing the last date of submission of application to 28/2/2016.
It is a corrigendum.
Corrigendum. It is a corrigendum.
If it is a corrigendum, then different consideration. Corrigendum means what is corrected.
Yes.
According to you, only
in respect of the
age alone is corrected.
Keeping in view the judgment of the Honorable Court.
My lord.
That is 35 to 32. So this is also not disputed.
Yes, I am not disputing that. The last date in the corrigendum was fixed to 28/2/2016. She applied pursuant to the corrigendum because she was overaged. But she acquired B.Ed qualification also prior to 28/2/2016. But after the last fixed in the first advertisement, that is 39/2014, she passed B.Ed on 19/2/2015. My lord, interpreting that very resolution and the corrigendum, the coordinate division bench of this Honorable Court has answered that, relying upon Rekha Chaturvedi's case and other cases. My lord, may kindly see that. And here also the learned single judge has also relied.
Thank you for giving 2 copies to us.
Yes. Yes.
Which paragraph?
Yes, your lordship may kindly come to paragraph 8 first.
It refers to Rekha Chaturvedi.
Rekha Chaturvedi. Then para 9 and 10. Other judgments.
Rekha Chaturvedi may not be strictly applicable.
May not be strictly applicable. Then your lordship may kindly come to para 12. Here the same advertisement, same corrigendum. It must be mentioned here that on 8th April 2016 in the present writ appeal, the following interim order was passed. Interim order has been quoted. Then your lordship may kindly see the second subparagraph. Considering the aforesaid aspects, we are of the opinion that the appellants have made out a prima facie case for interim protection. Accordingly, it is directed that the respondents shall accept the hard copies of the application of the appellants for the post of Sikha Sahayak with reference to corrigendum number such and such dated 9/2/2016, same corrigendum, issued under Annexure 5, and to allow them to participate in the selection process. However, their results should be kept in sealed cover and should not be declared without the leave of the court. Then your lordship may kindly come to para 15 and 16. In view of the settled legal position, in that case, OTT2 qualification was acquired later. In view of the settled legal position explained in the above decisions of the Supreme Court, this court is not able to accept the plea of SME department that the requisite qualification of OTT2 was not possessed by these appellants as of the last date for filing of the application in terms of the advertisement read with corrigendum. Even the plea that corrigendum relates back to the original advertisement overlooks the fact that as far as the present appellants are concerned, they became qualified to apply only because of the relaxation of the upper age limit pursuant to the orders of this court as explained herein before. In other words,
So it has to be revised at a date.
that is, yes, that is 28 to 2016.
Mr. Monty, we read paragraph 16. Slowly in the
Even the plea that the corrigendum relates back to the original advertisement overlooks the fact that as far as the present appellant are concerned, they became qualified to apply only because of the relaxation of the upper age limit pursuant to the order of this court as explained herein above. In other words, it is only by virtue of corrigendum that the appellant came to apply for the post. If the corrigendum were to relate back to the original date, they would not even be qualified to apply. Therefore, as far as the three applicants are concerned, it cannot be said that the relevant date for determining whether the appellant possesses the requisite qualification has to be the original date of 30th September 2014. It has to be revised date in terms of the corrigendum.
Otherwise, but for this paragraph, we would have interfered because there are some judgments which Samaraditya Pal cites. But there is a judgment of our High Court now, coordinate bench.
But
have you filed a SLP against this order?
That I have to check.
This is single judge order.
This is a
division bench.
Division bench.
In the writ appeal.
Writ appeal.
This is my lord.
Honorable Chief Justice, then Chief Justice.
Then you have to make a very strong case to persuade us to refer to the larger bench. We don't think that way.
And so far as Punjab High Court is concerned, Your Lordship may kindly see this. It's a single bench. It's a single bench. The same principle has been reiterated that
what if we read text of the notification, intention is to give benefit to those
who have
become overaged.
Requisite qualification, but they were age barred.
Yes.
It is intended for them, whether they call it as corrigendum or addendum, whatever.
Yes.
It is more an addendum, not corrigendum.
But in all the judgments it has been held that once the last date is extended, maybe by corrigendum or any other notification.
Depends upon on what ground.
So eligibility criteria is also extended. And by the last date of corrigendum, the petitioner has acquired.
That is a difference.
And he has rendered more than 10 years of service.
Yes, sir. 10 years of service.
10 years of service. He is
Brother,
continuing.
what is there now? We want to see.
So far this particular case is concerned. The corrigendum was issued only when the order has been passed by this Hon'Ble Court. Keeping in view, so far the age relaxation is concerned.
Correct.
So far this qualification is concerned, that is nothing to do with.
No, under the very same corrigendum, this order has been issued.
Yes.
Can a bench take another view? What will people think about us?
And she was engaged. Subsequently, her engagement was cancelled. Interim order was passed by this Honorable Court protecting her. And by virtue of the interim order, she has been continuing since 2016.
So far the
He has rendered more than 10 years of service.
So far the disengagement order is concerned. And I will look to Annexure 7 and page 73 for a moment.
That disengagement order?
For a moment. 73.
Same on the ground.
But who became it? Only they will be contemplation of that. You had disengaged her?
Yes. Can I have a glance to that order of disengagement at Annexure 73.
That is after the cut-off.
Joined on 31st March 2016. This was order dated 3/5.
Yes.
1 month after.
This was stayed and
On minutes cross-checking of the documents submitted by the petitioner, such and such, Kendrapada for the post of Shiksha Sayak 2014-15, pursuant to the corrigendum dated 9/2/2016 of the UPEPA, it is ascertained that she has acquired B.Ed qualification after September 2014, which is not permissible in accordance with letter dated such and such on 1/3/2016 of the State Project Director.
This is issued on
It is a 3/5/2016.
and division bench decision is of 2022 November.
yes.
No. Perhaps she has married, begotten children.
She has rendered 10 years of service.
10 years.
And she is continuing.
Justice of the case we have to look into. We cannot be that cult.
We are not against anybody, my lord. So far this factual aspect is concerned.
But very same corrigendum is interpreted by the coordinate bench.
My lord, whether it has been challenged or not, can I verify it?
Whether this is challenging SLP, what of sir?
WA number 102 of 2016.
Take this and find out whether any challenge is made to that order. Otherwise, it is covered by the judge.
Yes. And single judge has also relied upon that.
That is. In this case, how many days of delay?
72 days.
72
days. Condone the delay.
It is 72. 71 days.
Any specific?
And the services of our contemporaries have been regularized.
That is a issue.
Because there is a scheme.
Having the
6 years.
requisite qualification and age.
Yes. And she has rendered more than 10 years of service.
She had applied after the corrigendum. And
Applied
She was
after the
selected. She was given
was
engagement.
also mentioned that she had acquired it in between.
Where is the suppression?
Yes.
I am not saying suppression.
No, you could have rejected then and there.
Yes.
You got
Exactly, my lord. By the time of scrutiny, it could not be done. That was done immediately, my lord. Kind of a glance with 31 March
After
2000.
getting her employed.
1 month on scrutiny.
Why even a day?
It should be before one gains entry to the employment.
That is by mistake on scrutiny. They have skipped for that on minutes cross-checking of the documents. Because they are in the impression, so far the age relaxation, so far the education is concerned. These are all two separate aspects, so far the advertisement is concerned.
It has attained finally. This intra-court appeal by the state and its officials seeks, kindly be seeking this, seeks to call in question a learned single judge's order dated to 4/3/2025, whereby respondent employees WPC number 9688 of 2016 having been favored, the following relief was accorded to her, has been accorded to her. First, next perfect term. Learned AGA appearing for the appellant state vehemently argues that initially the recruitment advertisement was issued
11/9.
Issued on
11/9/2014.
11/9/2014. Subsequently, a corrigendum came to be issued on 28/2/2016.
No, 9/2/2016.
9/2.
Fixing the last date to 28/2.
9/2/2016. Whereas fixing 28/2/2016 to be the last date for filing the applications. First of all, the object of issuing the corrigendum was to benefit the eligible and qualified candidates under the original advertisement who could not stake their claim for appointment because of age bar. First of all, the respondent employee admittedly having not acquired the prescribed qualification within the
B.Ed qualification, only B.Ed.
Only B.Ed.
Within the last date prescribed under the original advertisement, comma, she has been disengaged by the order dated
3/5/2016.
3/5/2016. First time. He also tells that by that time, although the respondent had already gained entry to the
1 month
employment,
1 month.
say a month or so, come on. The fact was ascertained after on minute cross-checking of the documents submitted by her. First, this aspect having not been duly adverted to by the learned single judge, comma, impugned order suffers from an infirmity warranting interference from this court. Next paragraph. Learned advocate representing the respondent employee per contra opposes the appeal, contending that once the last date for filing application is extended, comma, the candidates who obtain the prescribed educational qualification even subsequent to the date mentioned in the original advertisement itself would become eligible to apply, and therefore the impugned order is inexplicable. First off, if presses into service, a decision of coordinate bench of this court in Viswaranjan Viswal and others versus State of Odisha and others, in writ appeal number 102 of 2016. Okay, between so and so, decided on 29/11/2022 in support of his submission. First off, he also presses into service the decision of a division bench decision of Punjab Haryana.
This is single bench.
A single judge decision of Punjab Haryana High Court in Harman Preet Singh Wadhwa versus State of Punjab.
Para 20.
Manu stroke PH stroke 0322 stroke 2016.
Para 20.
Para 23.
22.
In that para 16, earlier edition, it's division bench coordinating. That's Viswaranjan. That is para
16.
16. Next paragraph. Having heard that counsel appearing for the parties and having perused the appeal papers, we decline indulgence in the matter, in as much as the question raised is no longer res integra, comma, the same having been stoutly answered by the coordinate bench in Viswaranjan Supra, which are related to the very same recruitment process and the very same corrigendum.
Yes.
Same corrigendum.
Same corrigendum.
Personal. At paragraph 60, comma, the bench has observed as under para 16, you just reproduce it. Yes.
In para 12 also, that corrigendum has been referred to.
At para 12 of the decision, the corrigendum is specifically referred to. Next paragraph. Learned counsel representing the respondent employee is right in pressing into service the Punjab High Court decision in Harmanpreet Singh, Para 20 Supra, wherein paragraph 22 reads as under. See, only this part. I have marked it in yellow. Okay? We should take to that as well. It need not be separate character. Next paragraph. There is also force in the submission of learned counsel appearing for the respondent that once after verification of all the documents, the appointment order has been issued and the appointee enters the portals of the employment, it is not open to the other side to say that the appointment order has been wrongly issued. And more so when verification was of the documents was already undertaken. First, no explanation is offered by the appellants as to the circumstances which resulted into relooking of the documents produced by the respondent employee. First, it is not their case that any fraud or fabrication has been perpetrated by the respondent, either. First one. Next paragraph. One more sentence. The respondent having been employed with effect from?
With effect from? That is 31/3/2016.
31/3/2016. And he continued the service by virtue of interim order obtained in the subjected petition. It would be highly unjust to ask her to quit the employment now. And therefore, the writ court cannot do anything that would be unjust. First off. Next one. In the above circumstances, this appeal being devoid of merit is liable to be rejected, and accordingly, his costs having been made easy.
Lordship, direct for implementation of the.
They have not implemented.
They have not yet implemented because of the. I have been continuing by virtue of the interim order.
He is continuing, then what is the question?
Then, my lord, all consequential benefits, including regularization, etc., that has been directed.
But regularization you have to raise.
That is on their pyramid, no? It is
open to the petitioner to seek regularization in accordance with law.
And may I request item 17, the other side is also there. Passover item.
All right. Yes, sir.
Once the petitioner is there.
Yes, it was not very good. No, it's not. There are many court halls here, na? You have to run from one court to another. You can't ask the advocates to be seated in the same court throughout, like a captive audience. Yeah.
Once the petitioner herein is a MSME, lordships, it had availed a loan, term loan of 28 crores and 5.2 crores cash credit in the year 2013, lordships. Subsequently, my lords, in
totally 28 crores on
28 crores is a term loan, lordships, as per their admission in their section 7 application for the NCLT at page 32.
28 crores is term loan.
Term loan and the cash credit 2013, lordships. December 2013.
Another is how much?
Another is 5.2 crore cash credit.
Just one small submission. I'm on caveat
Just 15 minutes back, I have served with a copy of it.
So we'll have that question.
Yes.
Yeah.
My lords, the auction is going to happen on Monday, lordships. And my lords, I have annexed a check DD of 5 crores. Their reserve price is 20.97 crores. And my lords, I have also pleaded.
Plus, there is an auction going on in the liquidation process. They can participate and submit their.
But my lords, is a slump sale. If I participate, then for 3 years licenses would have difficulty, my lords. If we go on an ongoing, my lords, the promoters want to participate in these things.
But I will not halt the auction at all.
No, my lords, I don't want. I just want to offer. I just want to offer an
attempts in this court. Your Lordship have on 2 occasions dismissed their writ petitions. On 2 occasions. And I don't.
My lords, I will be very fair.
Disclosed in the writ petition also.
Are disclosed in the petition.
One instance has been disclosed. The other instance has not been disclosed in the.
You file your objection to it.
Yes.
Yes. Call on.
This is the order also.
I'm not.
Use copy because they will. Sometimes clients will not brief at all.
May I submit? Me and Mr. Samantra, we go back because ever since I started my practice, because I know that he doesn't know, but it is there. Where similar OTS prayer had been rejected by your lordship, saying that if you have anything, go to NCLT because NCLT is in section of.
No, one of the orders are annexed, my lords.
One is annexed.
One is
annexed.
I'm
The other is the suppressed.
My lords, may I request one thing, lordships? As per instructions from the promoters, my lords, they are prepared to match that reserve price of 21 crores, which is coming up on November, my lords, 9th of February, my lords. And it's a liquidation order where the order directed them to consider me under 32E and F because ongoing concern, my lords. And if they go for a slump sale, it goes to a third party. 3 years, they will not be getting licenses. It will go to scrappage. And thirdly, my lords, 150 odd families of the locality depend on it. The promoter has created it. And my lords, OTS of 2023 December, admitted their document.
We'll post it tomorrow.
Please, lords. Please, lords.
There's a waiting in that. Would it be Monday?
Monday you are holding the auction.
Here, your lordship will kindly note this. 6th of January.
One second.
Of January.
My lords, one more thing.
Petition filed yesterday, listed to.
My lords, one more thing. One more thing. Lordship, their document, I just put one document to lordships. Lordships in 2023 December.
Caveat, Millers, I'll show this, Millers.
My petition, let me answer.
This caveat, Millers, I have filed. Caveat returned unserved. To which address? The same address from which the writ petition is filed. With the instructions, addressee left, returned to sender. This is the second time that in the earlier writ petition, which I showed to the order, which I the day 2024, there also they adopted the similar practice. Writ petition filed from the same address, Mayuri Plaza address, addressee left without instead caveat returns. They don't serve caveat.
It's a financial issue. I'm coming to their admission, my lords.
6th January is the notice. Yeah. Writ petition gets filed on 4th February after almost a month. And the caveat petition gets.
Addressee sent you that?
Yes.
Let us see the type cost.
Yes, my lord, this is the caveat where your lordship will see the endorsement and will see your lordships may kindly take.
Go to cost statement.
I have, my lords, my lords will take the cost title Gitishri Patro. Gitishri Patro 2. P2 and P3.
Saswat Kumar Acharya.
That's me.
The party is?
Yes.
Party is Deepak Kumar.
Deepak Patra, Gitishri Patra.
Yes, Mr. Gitishri Patra is petitioner number 2, Lord.
Third floor. How they are describing the
Resident of N4221.
No, that is P1. P2, Millers will see the address, flat number 3, 3rd floor, Mayuri Plaza.
P.S. Patra. P. Sambandhu Patra. No.
Yes. P2.
No, Gitishri Patra.
Gitishri is again Mayuri Plaza.
Flat number 3, 3rd floor.
Yes.
Mayuri Plaza.
Yes.
Even otherwise. About identity of the party, no issue. They say party has left us. Therefore, everything is correct. But party has, all the three have left.
Yes.
That time also they had left. No,
Yes.
not really.
This is, I have the earlier caveats also. This is the earlier caveat again. And that order, my lords, your lordship, I have the earlier writ petition. There, my lords, all three had the same Mayuri Plaza address.
Appear to be handing blow with the postman. Call next week.
Minutes, may I submit?
No, sir. Next.
Grateful, Lord, sir.
Item 24.
May I please, your lordship? Yes. Your lordship has already decided that identical. There are two decided analogously by the Honorable single judge. And in one matter, the appeal was already dismissed, and this is the second, my lord. Regulation and your lordship. The lordship in the first paragraph mentioned two writ petition 17811 was the writ appeal decided by all. The second one, the present writ, my lord. Present appeal is
38309.
My lord.
This is 38309.
Yes.
Yes, sir, they already covered with it.
That mobile health unit.
Already regularized, and the order has already been complied also. मोबाइल इधर रेगुलर है ये तो मुझे वाला है यार इतने ही इधर नहीं था और कहीं इतना बोल
Same order to be printed.
My lord, the same.
As it is. Because of
there's some correction.
The subject matter of this appeal is absolutely similar to the one in writ appeal number 1368 of 2025 between state and others versus Sudhindra Changada Maji and others. Heard and decided by this very court, wide order dated 15/1/2026, against the appellants. At the next paragraph. At the paragraphs 3, 4, and 5 in the cognate appeal, we have observed as under. Okay. 3, 4, 5. Below that, one more line. What has been observed here in above equally applies to the case of appellant. First, this apart, we are told at the bar that the order is already implemented. No.
My lord, my client has already been regularized.
The impugned order having been already implemented,
in respect
regularization has been granted.
In respect of respondent, present.
In respect to the respondent employee. First. In addition, the appeal is filed after booking a delay of
168
days.
168 days. First up. We are not seeing even one single appeal filed by the state without brooking delay. First up, it sounds strange and falls foul of the underlying philosophy of prescribing limitation period for appeals. First, next term, in the above circumstances, this appeal being thoroughly unworthy of merits is liable to be dismissed, both on the ground of on merits and on limitation. First, Ordered accordingly.
Timely occurrence.
It's good. Black pen.
Item 25.
My lord.
Yes.
My lord, I have filed a memo for modification of order. I have mistakenly, confusingly tell that all should be included in party, but in previous order. No. So, they should be as pro forma respondent, my lord, because previously Honorable Chief Justice ordered me to make them as pro forma respondent. There is next.
I mean 24/12/2012.
They should be treated as a pro forma respondent, my lord, and need not make any notice to them. As they
You only had filed application for their impleadment.
Yes, my lord. Pro forma respondent.
Means what?
Need not to be party.
Why did you make them party?
My lord, I have little confidence.
Then you withdraw that application. Once you make party, notice has to go to them.
My lord, I have filed an IA, including them.
If they are not necessary party,
Not necessary.
nor proper party, then why did you make that application?
Confusingly.
But once they are made parties, you have to take notice to them, because otherwise res judicata will apply. We do not know what all we will say in our order.
Yes.
And if we say something,
Yes.
and that may be against them, we do not know.
No, sir. They are,
We do not know. Because you have made them parties.
sir, confusingly.
Then you apply for withdrawing that application.
Withdrawing the IA.
IA itself.
Yes. And another thing, my lord, I want.
No, first that you do. Then we'll consider rest of the things. Because all other things, as long as they are on record, notice has to go to them.
Yes.
If you give a memo, you saying that by mistake all they came to be implemented by me, therefore you delete those people, we'll make that order accordingly.
Yeah.
If you want to file a memo,
Yeah, I want to withdraw them.
you want to withdraw give the memo.
That,
You write.
And another thing, my lord, I want to just submit 1 minute. My lord, sir, already told that in Shiksha Sahayak, they have given already 7 years of age relaxation, 35 to 42.
This is different.
And another thing, I have 6 years of age relaxation on Odisha Special Armed Police.
This is armed police. This is armed police.
Armed Police.
Fitness is required.
Because the vacancies are many.
Age relaxation is given.
What's
Fitness
your
is
case?
required.
My case is, my lord, Odisha Police SI recruitment. I want 4-year age relaxation because this ground and this ground is totally same. The recruitment last came in 2018. Now they published in 2024. In similar situation, Odisha Special Armed Police, the last recruitment is 2018, and now 2024 they gave recruitment, and Honorable Single Judge also give 6-year age relaxation because recruitment not coming every year after 6-year period. So they have already accepted that and given 3 years of age relaxation. But I am only bad by 1 year extra, 4 years of age relaxation I want.
What is your age?
Sir, 28.6.
28.
28.6.
There is no 0.6, either 28 or 29. It is like that under the Indian Majority Act 1875. There is no fraction.
Sir, the last, the age is 28. 25, initially 25, but they have accepted it and increased it 3 years, 28. But my age is 20, more than 20.
You withdraw, you make file a memo. Party in person submits that OP numbers 245, 445, where arrayed as a pro forma parties, and that they are neither necessary parties nor proper parties.
Affected parties, they are not affected.
In the light of decision of apex court in Rajia Begum versus Shahnaz Begum, AR 58 SC sites. Therefore, he seeks leave of the court to disarray them from the cost title. First of all, he has filed a memo to that effect in the open court. First, next, in view of the above, the said party, they have 58 signs. Yet the said parties are disarray. You have not amended the cost title.
So just to find the constitutional cost title, he has not cited.
The cost title,
He has not cited.
the question of amending the cost title would not arise in as much as he had not filed the amended cost title. In terms of the earlier order dated 24/12/2025. First. Yes, you take one post in the second week of March. Yes.
Item 16. I'm sorry, my lord, I had to take a Passover in the morning.
Right. Yeah.
My lord, before I take to the impugned problem which my lord, the petitioners availed 3 loans. My lord, one of rupees 64,40,000.
That was in which year?
My lord, 27/12/2018. Another 25,50,000 on 31/12/18.
Yet another?
Another of 2 lakhs personal loan on 8/4/2020.
2 lakhs.
2 lakhs. The entire loans
2/8/4.
My lord, it is 8/4/2020. My lord, the entire loan became NPA on 31/3/2021. My lord, bank total aggregate interest up to 28/2/2023 came to 1 crore 9 lakhs 96,567.
Yes.
My lord, auction notice was issued way back in 28/11/2025. We approached the bank authorities for compromise of OPS and deposited 10,50,000 as on 26/12/2025.
Along with application for OTS.
Yes, ma'am.
Is it along with OTS application?
Yes.
Application dated 26/12.
26/12/2025.
You only gave that 10 lakhs or?
No, my lord, it is 10% amount of the OTS proposal.
But what you have paid is less than 10%.
My lord, 10 lakhs 50,000 I paid.
Correct. But the amount due is 1
crore 9 lakhs 96,560.
9 lakh.
1 crore 9 lakhs.
Not 1 crore 99 lakh.
No, my lord, 1 crore 9 lakhs 96,567. Thereafter, there was no further communication by the bank. My lord, they filed one OA case, which is still pending before the learned DRT.
Yeah. What relief you want?
My lord, now, my lord, they have issued an auction notice under Annexure 1, page 10.
Yes.
My lord, now I am ready to pay 1 crore 5 lakh at a stroke within 15 days. But a third party will pay for me, which they are not accepting. She says you should pay. My lord, anybody who pays that money, the bank will accept. I will deal with them.
You pay for the bank.
It's bank.
Read section 2 or 3 under Indian Contract Act. Consideration may move from the promisor or any person on his behalf. This is the difference between Indian law and English law. Under English law of contract, the consideration should move from the party only, no third party. Now he is ready to pay the money. When it is scheduled?
My lord, auction is scheduled to be held on, my lord, 25th February 2026.
25 February.
Yes.
So we have another 20 days. You are paying it within 20 days.
Yes, ma'am.
How much money you are?
1 crore 5 lakh.
Why 1 crore 5 lakh? It is whatever amount is there, that amount.
My lord, I am ready to. I am ready.
Memo.
Yes, I file a memo.
You file a memo now. Then we'll issue notice.
But what the instruction I have got is uses more than that.
You whatever amount is due, you tell us. If he pays that, we will hurt the. After all, bank wants money.
Money.
Or the building.
I'm.
Oh, you
just
want money.
supply me a copy.
Nothing beyond the money.
Supply me a copy.
My lord, I am handing over copy to my learned senior.
You better will call this matter on Tuesday. Tuesday. You have to on Tuesday. You have to bring some money to attract us.
My lord, at the moment he is penniless, but a third party, I'll file an affidavit before your lordship that a third party will pay the 1 crore 9 lakhs 1 crore 10 lakhs will pay. Because
Not 1 lakh, whichever amount is due.
My lord, their due is 1 crore. My lord,
Whatever amount is due.
Yes, my lord, it is 1 crore. My lord, it is 1 crore.
In other words,
yes,
entire money your client wants to pay.
Yes, 1 crore 9 lakhs 96,560.
If you pay entire money,
yes,
within the date which now we have said,
yes,
we'll direct the bank to accept it and cancel the auction. Otherwise, auction will go on.
Yes,
take off. Can we do that? Anyway, your money will come. You file the memo first.
Yes, ma'am. Memo.
You file memo. Correctly, you should write it in a good English.
Yes, ma'am.
Many memos are so bad that we feel very reluctant to reproduce them in our order.
Well, I'm just not filing.
Petition prayer reads as under. Learned counsel for the petitioner argues
67
that his client is ready and willing to pay entire amount due
as per the notice
in terms of 3 loans, namely 64.40 lakhs rupees, 64.40 lakhs sanctioned on 27/12/2018, comma, rupees 25.50 lakhs sanctioned on 31/12/2018, and 2 lakh sanctioned on 8/4/2020, along with all the interest that has accrued. First off, he complains that he alleges that the bank is not ready and willing to accept the amount, and therefore the bank should be directed to accept the entire amount due and receive the auction notice. Dated?
Well, auction notice is held to be on 20.
Auction notice dated.
Auction notice dated is, my lord, 23/1/2026.
Auction scheduled to be held on 25 February 2026 in terms of auction notice dated 23/1/2026. Learned panel counsel appearing for the OP Bank opposes the petition, contending that the petitioner is a chronic defaulter and his loan account came to be certified as NPA with effect from 31/3/2021, and therefore inevitably the bank has marked the security property for auction in terms of sections 13-14 of Surface Act 2002. First of all, he opposes, so contending, he seeks dismissal of the writ petition. Next paragraph. Having heard the net counsel for the parties and having perused the petition papers.
And my lord, another line may be added. Dues is more than what he is submitting.
No, no, he did not say. With that part we have left deliberate because it's a matter of calculation. Having heard the net counsel for the parties and having perused the petition papers, we are inclined to grant a marginal interference in the matter as under in as much interference the matter as under in as much as the borrower is ready and willing to make entire payment of the amount entirely due as per the loan agreement, before the property is being auctioned.
Well, one thing.
Yes.
Whatever is due, they have not supplied to us. As per notice, whatever they have given in them.
No, not as per notice. They will tell you. If they tell you how to pay.
Yes.
Learned counsel also very fairly submitted that the amount due needs to be intimated by the bank as on date. To which proposal learned panel counsel is fairly agreeable. First off, the interest of the bank is to get the loan amount along with interest accruing due thereon and nothing beyond that. First off, the mortgage is for securing the repayment and not for anything else. First off, banks are held to be an entity under Article 12 of the Constitution of India, while the Gujarat State Finance Corporation versus Lotus Hotels. In 80s, 83, 84, 85, something when I was a student, which is that judgment. Gujarat State Financial Corporation versus Lotus Hotels Private Limited. They are 1982. Write down that. that give the citation. So and so. First one. When the borrower, because of the difficulty, could not repay the debts as undertaken, the lender is more than justified in invoking the mortgage or to otherwise secure the repayment by auctioning of the mortgaged property. Therefore, we cannot find fault with the bank in scheduling the auction on 25 February 2020, as rightly contended by the panel counsel appearing for the bank. First off, however, when the borrower is ready and willing to repay, maybe belatedly, the bank has nothing to lose in as much as the delay period also would attract interest and such other charges admissible in law. First one. In the above circumstances, this writ petition is pulled off with the following terms. 1. The petitioner shall repay the entire amount due. The respondent bank shall, OP bank shall, inform in writing and over phone to the petitioner borrower the amount due, the entire loan amount due, along with interest accruing.
Excluding my deposits, because 10 lakhs.
No, that will say that is accruing due. Due. Of course, after giving due deduction of the amount paid in last week of December 2020, first week of December.
It was paid on 26/12/2025.
Allegedly paid on 26/12/2025. 25. Within 1 week from today, 10 days from today, within 10 days from today. Next, 2. On such intimation, the petitioner shall remit the entire amount on or before 20th of February 2026. First up, unconditional. First up. 3. If the amount is not remitted as indicated in the preceding direction, in the immediately preceding direction, the scheduled auction shall go on.
One. They will accept money even from a third party because
number 2, what you are saying? This amount may be remitted by any person, by the petitioner or by anyone on his behalf.
Let them do within 7 days. So that
10 days.
10 days.
They will do it before 7.
Today is 5th. If
Correct.
they make it 10 days, it will be 15th or 16th because 15th is a holiday. If they do,
you keep money ready.
I'm ready.
Order you take to your lender,
Yes.
some other lender.
I will convey the message that immediately they will convey.
Then they will withdraw the DRT case. Once I pay the amount, because DRT case, that another case is running against me.
Automatically account will be closed by that.
3. It hardly needs to be stated that on the remittance of entire loan amount outstanding, the bank shall withdraw
OA case
The
number
OA number
176 of 2023 filed
pending
before
on the file of
Cuttack.
DRT Cuttack, and further return the mortgage documents to the petitioner after discharging the same.
Yes,
Okay.
grateful. Urgent copy of my lord.
And further, the auction notice shall be received. Okay.
Grateful.
My lord is always mentioning entire dues. For that reason, I keep quiet because he is telling 3 loan. But in my what instruction, that is about 13 loans. Is absolutely. So my lord has completely.
My lord, I will pay the entire money. I am ready to pay the entire.
That I will convey.
There may be other loans also. We are very
Specific.
Na? There may be other loans also into breaking.
Grateful.
Objection.
Item 26.
I have short prayer, my lords. Item number 36 in the list. Maybe it is a matter relating to employees who are 30 years they have worked as a bank regularization matter in ultimate hard on part. So if it does not reach, can I pray it may be taken up at the top of the list tomorrow?
How? Tomorrow?
If it does not reach, if this matter does not reach, your lordship has heard it. And we were discussing.
Tomorrow I am not sitting.
Then any convenient day to your lordship.
If it does not reach, perhaps it may not, because I have to go little early to the airport. Let us wait.
Can we kept on 12 if it does not reach, if your lordship is.
Yes.
Fine.
Now, may I please, your lordship?
Item 26.
Yes. In this case, my lords, I have challenged the order of the Honorable Single.
I'm for the respondent. I'm appearing to.
You want to appear? No issue. Okay.
Lords, I am challenging the lords order of the lords Honorable Single.
The matter. Ready. And on merits.
There is delay of 141 days, my lords.
Condone the delay.
On the delay also, my lord will appreciate what is the case and how the delay has occurred.
Unless delay is condoned, we cannot enter into the realm of facts. What is the explanation for what is your claim?
My lords, my claim is that my lords.
No, client. Who is the appellant?
Canara Bank, my lords.
Canara Bank is a bank. I am the auction purchaser. And for last three years, I have been running after them to take the possession. And they have not delivered the possession. And they are also, and here in this appeal also, they have tried to mislead this Hon'Ble Court.
By argument to cancel.
Yes.
How do you know that he is going to mislead us? He may not mislead us at all.
Now I have got.
Now you have put him on KVL to mislead us. Yes.
Millers.
Yes, sir.
The main ground is that Millers. Millers, beyond the roster assignment, Millers, the Honorable Single Judge was pleased to Millers entertain this matter.
That matters come before whom?
Millers, Honorable Single Judge, Division Bench, Millers, because it relates to surface matter, Millers. Your Lordship, just have a glance with the prayer of the Millers.
Then we did this as writ petition only. Let him argue the matter and we'll consider.
Millers.
So that way you start argument.
Millers. Your Lordship, just for a glance, Millers. Two things, Millers. Really, his prayer is that, Millers, sales certificate.
Well, then what we do is, because of apex court decision in state of Rajasthan, which is that 96 Supreme Court, 97 Supreme Court.
Millers, Guardian is Shipbuilders versus Millers, JRC Limited.
There is no famous judgment, the 1996 Supreme Court. A judge who has no roster, passes no order.
Exactly.
What do you say about this roster?
Roster was there, Miller. As per this subject matter assignment, that was within the roster of the single page.
So that roster you have to show by showing the sitting list. What are the matters assigned to us?
Well, then it will be on Monday.
Surface is always in division bench.
Yes.
This is, I am not on the surface matter. I am on the question. I have already taken the auction.
Wait, it's under the auction took place under the surface.
That is there. The only thing is they have to give me the possession.
That's all right. Now we will set aside this order and we will get the matter posted before us. Writ petition. So that once for all this can be. Okay. Otherwise it goes on like this.
Yes, sir.
And what is the ground on which you are resisting? Have you received money, auction money?
Yes, madam. We have received minutes. We have also issued minutes sale certificate. We have also registered the sale certificate minutes.
But possession you are not.
No, we have also given minutes. But his dispute is that minutes, though we have given the key minutes, he is saying that I don't know on what circumstance you want.
My lord, I will be.
Possession he wants, I don't know. Minutes. I am referring that possession.
One second. Are you ready and willing to give possession?
We have already given.
You have given. Means what? Means what? You have given
by handing over the key minutes of the key of the premises.
1 second. 1 second.
Your lordship, just a glance.
Listen.
You have no patience to.
No, sorry, minutes.
Yes, brother. He is saying we have given. You want property or you want litigation?
No.
You want property.
You want property.
Yeah. 1 second. If we make arrangement to put you in possession of the property.
No issue.
No issue.
No issue.
We'll ask the police to put your client into possession of the property.
Yes.
Okay. And if bank officials
only
then will direct the police to arrest them.
Yes, yes.
Well, that is enough. And one thing is, for this delay, the honorable single judge, they have only passed some cost on them.
How much?
5,000 for each day of delay, the handing over the possession.
So you want to close the bank itself?
Question is the audacity. May Lord just have a glance the writ application and how they have misled it. From time to time they are misleading.
You want possession of the property.
Possession.
If we admit this is an arguable case for admission, if we admit this and keep it for 5 years, what will happen? Instead of that, we are suggesting to you that they will say possession is already given to you, and they also undertake that they will not hover near the property. Okay? And you ask your client to go there and videograph everything that he is in possession.
That is there. Only another cost, they have made me to spend some money. They have asked me, they have issued a letter to me saying that you remain prepared by purchasing the stamp papers for registration of the land. So I have purchased that by spending 3 lakhs. So now they are making a U-turn, not coming to register the land also.
No, they say
already
registration.
Yes, I have annexed.
They have given me, Lord. Just that's why
you understand law. Can't you understand law? Supreme Court said the sale certificate itself.
I am conscious, my lord. I know. But that despite they have asked me to purchase the stamp papers, and I have purchased.
You remit them back, get the amount back. They are not used now.
That stamp paper they have typed and they have given to me.
So you keep them with you. Why you are worried? You are not paid anything for that.
Once it is used by them, how can I reuse it? The stamp papers, that is I have annexed in the writ application.
You purchased the stamp paper and gave it to the bank.
They have asked me to
write it and
send to me.
For what for you had sent? After signing, they have sent it to you.
Yes, they have signed.
They have signed that.
They have signed. They have, after signing those stamp paper, they have remitted to me for the registration. And I have taken 3 lots in the, one has to reserve the lot in the sub-registrar office. So 3 times I have taken. Then they have defaulted.
I think that it has not been typed on the stamp paper. This is
stamp paper.
This is stamp paper. This is the e-stamp paper. It has
e-stamp paper.
You can get it returned.
They can be surrendered. For stamp pack.
Why not just have a glance in my...
Never seen stamp pack. Why are you nodding your head? To confuse us. What the stamp pack says in Karnataka, unused stamps are surrendered and amount is
after being typed, after being filled up.
See, if I doubt. If
I have purchased recently, I have purchased some land in your lordship city also in Bangalore.
You are saying
in Bangalore. That I have purchased and I have seen that. I am conscious of this, my lord.
No, you can't say that way. You have to return the pages of the statute book. Then lawyers should argue. What happens in the cutoff market is not relevant to us. What law says is important to us.
Though this is the stamp paper I have purchased.
Now you show that the under
that is used. That is used well.
Therefore, you show us. We'll give you some time. First, you take the possession of the property.
Of like,
Is it not property worth how many crores or lakhs?
50
lakhs.
50 lakhs.
49 lakhs 20,000 millions.
When you were supposed to give the possession?
Millions, we have given immediately millions. It was sold on 6/3/23.
6/3/23.
It was sold and we have delivered possession on 1/5/23 millions.
1/5/23
millions.
Who is there in that house now?
Millions, keys with the auction purchaser and nobody is there. Millions. Because
it's not in your possession.
It is not.
You say it is in their possession.
Exactly.
With effect from 1/5/2023.
23 millions. Yes, millions.
When did you register the sale certificate?
Sale certificate was registered millions.
Okay.
It was on 1/12/25 millions.
Do you have a copy of sale certificate?
Yes, millions. I have annexed it. I annexed 4 millions.
1/12/25 means that is after more than
Yes, millions. There is problem millions. Millions settlement operation is going on. For that reason, millions, they are not allowing us. And ultimately, millions, we approached and by showing the decision of this Hon'Ble Court, they allowed us to millions get it registered. Millions.
You have registered and sent the registered certificate to them?
Yes, millions.
When it was sent?
On same day, millions, on 1/12/25 millions.
How it was sent?
By registered post, millions.
Yeah, have you received the certificate? Sale certificate?
I have not received it. I have not. But if it is their sales certificate, he is showing that must have been received. I have not consulted yet. But anyway.
In that certificate,
millions.
Have you mentioned that you have given possession of the property already on 1/5/23?
Millions, sir. You not see me just a glance to Annexure 2 millions. Annexure 2 has page 51 millions.
We will not see any page. Even
no, it has been
acknowledged. An answer from you. Have you stated
millions
that possession of the property was handed to the respondent on 1/5/2023 already?
Yes, millions.
Sale deed is being
executed. Yes, millions.
Where have you stated?
At page 4 of the affidavit, millions.
You received the certificate?
Yes, millions. In the letter, millions. Letter enclosed.
Letter you cannot say. In the sale certificate, what does it read?
You not see just a glance to the millions. Annexure 4, series millions, at page 4 of the affidavit millions. Additional affidavit I filed millions. There we have specifically mentioned, we used to inform that the below mentioned scheduled property has been registered under section 89 of the certificate of sale. A copy of the registered sale certificate is attached herewith. Since the keys and possession of the property have been handed over to you, which you have acknowledged by letter.
Where letter dated 1/5/23?
Millions.
Where is that letter?
Millions. At page 51 of the writ appeal, millions.
This is Annexure 2, your letter.
Millions.
His letter.
My letter and it has been acknowledged. Signature is there, millions. Receipt copy. Receipt.
I handed over the key.
Yes.
That thereafter I have informed the person from whom they have taken possession is not allowing me. There was a big fight. Then I informed them that I am not able to enter inside. So you please help us to take the physical possession. So that is the main concern, Miller. They have to give me physical possession.
Whether he is also party here?
Yes.
He is a party.
Baro? Yes, millions. They are also party.
He is a party.
Yes.
We'll issue notice to him, so that it becomes easy for us to put you in possession. Otherwise, only litigation goes on, you will not get the property.
4 and 5 millions.
For the 3 years, I have my money.
Let us see. But you should know where the petition should be filed before the court, etc. things. At least property you should get, even though you have not got the property.
No.
When did you take the possession of the property from the borrower?
Borrower minutes.
And how?
By virtue of section 14 minutes, we have taken.
But in order.
14 minutes.
Issue emergent notice, returnable within 10 days. First off, a police notice shall also go to OP numbers
4 and 5 minutes.
4 and 5. First up. Appellant, respondent numbers 4 and 5.
Minutes.
Respondent number 4 and 5. You appear for whom? Respondent number?
One.
Oh, who is 3?
3 minutes, average 10 minutes. Unless they have already complied the order period.
Subrejistar is here.
In Kujanga.
Learned AGA, Mr. G accepts notice for respondent number 3. Learned counsel Sri Mishra appears for respondent number 1 and 2.
Myself, Mohan.
Appears for 1 and 2.
Only one.
2 is?
2 is collector.
Collector.
Notice G will take the notice for showing so. The police notice also shall go to P numbers, respondent numbers
4 and 5.
4 and 5. No. Yes. You take the steps now.
Minutes.
Immediately. Call this matter immediately after service. Okay.
In respect of limitation minutes? Limitation.
Let us see. They have to come now.
Minutes.
They have to come and say.
They have been noticed minutes in limitation matter.
Notice was issued to them.
Yes, minutes.
When?
Minutes by order of my lord. Minutes.
Already notice was ordered.
It's already.
Whether a notice served on them.
JD received from R1. Neither JD nor Hon'Ble.
So you said to post this matter immediately after service.
But I have to file requisite minutes.
Yes, yes, to be requisite. No, requisite is to be paid.
By Monday minutes. Today is Thursday, so.
Tomorrow we can file.
Yes,
so that they get the property.
Yes.
He has already.
And we are there to cooperate minutes because we have sold the obliged minutes.
Yes.
Item 27.
Item 27. I am there for the appellant, my lord. Challenging the order passed by Learned Single Judge in WPC number 33713 of 2020, dated 7/8/2024, I am before your lordships. There,
7/8/24.
my lord.
What is the?
My lord, the order is.
What is wrong with the order? Hemant Kumar Pradhan and other persons have already been paid.
That is what the Honorable Court has said. And also, yes, I dispute. Now I am disputing, but in the order itself, it is submitted at paragraph 5, next paragraph, your lordship.
Similarly, you admitted. Similarly, person named Hemant Kumar, Nihar Kumar Senapati, Rajesh Kumar Sahu, Kumar Jena, working in the office of the special land.
By releasing by 100% salary cost under ORSP Rule 2008 by Special Land Acquisition Officer Bhadrak on 27/1/2009, but the same is irregular and under review. Considering the facts and circumstances made by the London Council for the parties, the concerned department is directed to take positive view and consider the regularization of the present petitioner by releasing 100% salary under cost under ORSP Rule 2008, as has been done in the case of similarly situated persons. The entire exercise shall be completed within 2 months from the date of presentation of the certified copy of the order.
How you are agreed with?
My lord, because the fact remains, my lord, these petitioners were appointed irregularly.
No, he just said consider.
Yes.
He did not direct regularization.
Because some people were given benefit.
Then you have to be on the similar then. You cannot be disputing.
My lord, but what I am submitting, my lord, 5/9/2000, the date of that on which the petitioner entered, without any advertisement, interview.
We already know all that. Learned judge said, turn the pages of the file, take a decision, keeping in view the other cases where you have granted regularization. If you have granted regulation to similar people.
No regularization has been granted.
We do not. You take a decision on that. Whatever. This intra-court appeal is presented against the Learned Single Judge's order dated 7/8/2024, whereby
delay
the appellants Respondents WPC number 33713 of 2020 in favor. The following relief has been accorded to him. Will produce para 6. Positive view of this one. So the
Yes.
positive view does not mean you should grant the regulation.
Grant relief.
Yeah. Next one. Learned counsel for learned AG appearing for the appellant payment he argues that direction of the kind could not have been given by virtue of the impugned order, in as much as there are several factors which needed adjudication consideration at the hands of the authorities only, and therefore the impugned order is liable to be void. First, he also tells us that he also draws our attention to the observation of the learned single judge at CORAM 5 that whatever benefit has been accorded to certain persons, namely Hemant Kumar Pradhan, etc., is irregular and under review.
Yes.
Irregular inwards and under review inwards company, and therefore no positive direction could have been given. First, next one. Having heard learned counsel for the appellant and having perused the appeal paper, we decline indulgence in the matter, in as much as the learned single judge has only directed consideration, directed the appellants to take a positive view and consider the regularization of the respondent by releasing 100% salary cost under ORSP Rules 2008, as has been done in the case of others, similarly circumstanced others. First, there is no positive direction as such for granting, for according regularization and for releasing the salary cost. First of all, learned single judge has only indicated that if in the case of others, benefit has been accorded, that has to be kept in view while consideration takes place. First of all, such innocuous orders do not merit deeper examination at the hands of this court. First, next, in the above circumstances, this appeal is disposed of, clarifying that it is for the appellants to take a decision in the matter of regularization in accordance with law, and keeping in view all facts pertinent to the case.
Yes.
First of all.
Delay is there, my lord.
There is one more sentence about the other reason for non-interference is that the appeal has been filed after booking delay. Only so much. Put it somewhere. Item 28, registry to send a copy of this order to the respondent by speed post.
Item 28.
I'm for the sole respondent.
Yes, sir.
I'm for the sole respondent.
Which sole?
Pension matters.
SOLE or SOUL? There is one poem, I do not remember, my professor used to often quote it, by Shakespeare. Shakespeare uses both these words. In one sentence, he uses the word SOUL, and in another, SOLE. Below the expression. It was a sonnet. I don't remember the name of the title of the poem. Yes.
Here, my lord,
yes.
State is the appellant. Let's not condone the delay so that matter can be heard on it.
That pension matter.
Any day next week.
Delay may be condoned. I have no objection.
Next week,
330 days.
Next week or week after, any day.
Benefits.
This appeal by the state has been filed after looking a short delay of 324 days. First up, an application supported by affidavit in IA number 4946 of 2025 has been filed seeking its condonation. First up, some explanation has been offered and EGA says that it is plausible. First off, this is disputed by the counsel appearing representing the respondent, employee who happens to be a pensioner. First off, condoning delay would not add additional merits to the appeal to the disadvantage of respondent. First off, what happens would be matter would be heard on merits, on intrinsic merits. First off, that being said, a long delay of 320 days, 21 days cannot be condoned unconditionally, as rightly submitted by counsel appearing for the employee. First off, next paragraph. In the above circumstances, application having been favored, delay is condoned subject to the rider that the which appellant he will pay that much. No, there are two appellants. Appellant number 2 shall pay. Appellant.
Sole appellant.
Shall pay. You're right. The appellant state shall pay a sum of rupees. How many days it will be?
324 days delay only.
24. Up to 30 days, no, nothing. Remaining amount 20 rupees per day. We have made that short stick. They're subject to paying how much money it will be?
200,000 something.
5,900. 5,900.
Around about 5,000.
960.
will make that. The state can tolerate paying a sum of a cost of rupees 6,000 to the counsel appearing for the respondent on or before the next date of the hearing, which appeal itself runs dismissal on that ground. Call this matter on 16. 16, all right, Mr. G?
Yes, my lord. 16 of February.
Yes, sir.
Pension matter.
Only this.
Supreme Court has decided you have to implement.
Yes.
Item 29.
Hello. When you see the last order, my friends have taken time to comply with the order dated 24/11, which was passed by the coordinate bench. Sorry, 14/11. High Court was directed to comply the government's query, and government is to reply to my lord. That was the order of essence.
In the meantime, this Honorable Court has already clarified the query raised by the government in Home Department on 16/1, my lord. I am giving the copy. So it is up to this government in Home Department to supply the information as required as per order dated 14/11/25.
Yes, Mr. G.
Today I had just came to know that such a communication has been
17/2. In the meanwhile, you comply that. Whatever compliance is to be done.
Sometimes more, my lord, can it not be on 20th?
20th. For this matter on 20th February. 20 February.
20th, that's true.
Yeah. As requested by learned AGA Mr. G for the compliance of coordinate bench order dated 14/11/2025. Coordinate bench order is 14/11.
Yes, ma'am. 14/11/25.
You have to comply that order.
Yes, well, I have to bring.
Item 30.
2017 matter it is.
Yes, my lord.
Okay. Yes.
We are the petitioner matter.
Yes.
So the issue is that they have challenged the order of the land central tribunal. And they are saying that this circular issued by the DUPD, basing on the Indra Sani case issued by the Honorable Supreme Court, the DUPD issued a circular. Basing on that, we have selected a person. He is a ex-serviceman OBC.
Ex-serviceman and OBC.
OBC.
Sorry, SC.
SC.
SCBC.
SCBC. That person, the petitioner who is challenging the order of our selection, the opposition party number 1, is claiming that no, your selection is wrong. That you should not go on the basis of that selection because I am getting highest.
I am getting
highest mark.
Horizontal basis.
But we have selected on the basis, horizontal basis, basing on that circular. This is the crux of the issue. Let's see, may come to the page 84. Order of the third.
The person who has scored more, is he SCBC, OBC? What Indra Sahani says is, where there is a quota in public recruitment for OBC, because Indra Sahani did not consider SC, ST at all. It is OBC centric decision. If the OBC candidate secures more marks than the non-OBC, non-quota people, general merit quota,
yes,
then he will shift to general.
Yes,
for all practical purposes.
Problem. Here in the case, basically in this case, the deputy clarify official rundown, clarifying the position. What is the method basing on which, basing on the Indra Sahani case, the government of India should go on a process of selection for ex-servicemen, and there are two bases, either horizontal basis or vertical. So horizontal basis, what we have done, because of the basing on the circular annex of 4 page 87.
And what would happen vertically if it is done vertically?
If you done vertically, then it will contrary to the decision of the Honorable Supreme Court. We can't act it up. Because it is there, the advertisement is very clarified. There is three categories: SC, ST, OBC.
Correct.
So he is coming out of OBC. Basing on that, we have recruited him.
The other party.
He has not been. He has agreed for this. Okay. But we have selected on this horizontal basis because of this circular. So you can't go beyond this. This is the only issue.
Circular not put in challenge.
No.
They are only challenge the policy guideline.
Yes. That is circular dated 984 circular. 94 circular. Annexure 4 page 87. Issued by the deputy. A personal. This paragraph 3 clarifies the position. Question put in the light of paragraph.
Page number?
Page number 87. Annexure 4 of our
paragraph 2 we are reading, na?
Paragraph 3, yes. 3.
Percentage of reservation for ex-servicemen should remain the same as at present. An ex-serviceman selected under the reservation provided for them should be placed in the appropriate category to which he belongs. For example, an ex-serviceman who is SC will be counted against the SC reservation point. An ex-serviceman who is ST or OBC will be counted against ST or OBC reservation point. And the ex-serviceman who belongs to general category will be slotted in the general category level C point. In the legislative reservation roster. The latest judgment of the apex court had come. On this. Just look at it. Justice, Honorable Chief Justice Gawai.
I'm sorry,
Honorable Justice Gawai had authored that judgment.
I
Just looking.
yes, yes.
Heard government. Yes, Mr. Padi. Notice is not, this is for the hearing.
Yes, sir.
Yes,
Counter agenda, everything.
He seeks short accommodation for operation of principles of reservation, horizontal and vertical. In the light of decisions rendered by the apex court following Indra Sahani. Indra Sahani is 92. 92 subject. Yeah, 92 is so and so. Mandal decision. Yes. Called in the last week of February 22.
Pardon my lord.
Clarify many things. After that, Mr. Indra Sahani case, the position of the many things have Supreme Court is clarified.
But pardon my lord, but the issue is not relating to Indra Sahani's case. Here the case is that there is a two posts are there for the OBC category. And both the two posts have been given to ex-service category in the horizontal, my lord. And those two persons are in the below in the merit. That is the issue. Whether both can be given to the ex-service or not, that is the issue, my lord. And as per the, my lord, the rule says ex-service and re-employment of central services of post 2012, my lord, there must be 10% reservation for the ex-serviceman. So when the cut-off, my lord, the OBC is a horizontal reservation, it caught vertical reservation, it caught by the horizontal. So it has to be 10% from that category. So they can only make 10% from the OBC, unreserved, SC or ST. So beyond that, they cannot go for reservation, and they make it 100% reservation here, my lord. So that is the only issue decided by that London Tribunal. London Tribunal says it cannot be 100% reservation, both the posts should be given to the ex-servicemen. And those who are on the below in the merit, I am the highest mark getter in that, my lord, in the OBC category.
One part they are saying
that is the issue, my lord, decided.
Subclause 2, so they have, and thanks to my friend, they have annexed it and filed this affidavit. This should be read conjointly of subclause 2 also.
Of the circular.
Yes.
The rule, my lord. That is the rule, 12. That is called ex-servicemen re-employment of central services and post amendment rule 2012. In that, my lord, 10% reservation has been made for the ex-servicemen in every category.
Let us see. We'll also just read and come back.
Yes, sir. Only give a date, my lord, 26.
26. 26 February. Yes.
Obliged.
Item 31 has been adjourned. Item 32.
31 adjourned. Oh.
My lord, the state filed this appeal. The impugned order that page 57.
Here it is decided on par with Saudamini Nanda.
My lords, kindly see, my counter, the specific amendment was that it is not at par with Saudamini Nanda, which was not been dealt with.
No, show us that it is not on par with Saudamini Nanda.
Page 47, my lords, kindly down. Page 47, my counter, para 9. That it is most humbly submitted that within the said 11 left out candidates, the name of the petitioner was placed in serial number 10. It is further humbly submitted that as per the opposite report of the TI stated as there, only 4 number of vacancies of assistant teachers posts were available as on 36/1996. As for the availability of the vacancies, out of 11 left out candidates, only 4 were eligible to get the appointment. it is needless to mention here that the Saudamini Nanda was placed in serial number 4 in the left out list. As such, fourth meritorious candidate to get the appointment with the aforesaid facts, as only 4 vacancies were available at that relevant point of time. The said Saudamini, being the fourth meritorious, was inducted into the service regular primary teacher. The petitioner was.
Since the petitioner was serial number 10, question of accommodating him.
My lord, here case is that he is regularized. He is working as assistant teacher, primary school teacher, but he wants antedating from the earlier date, my lord. Earlier date, my lords, it is.
How many years of service you have put in?
My lord?
How many years of service you have put in?
I am 55 years. Another 5 years.
How many years of service you have put in? So
from the 2012, my lord, I have regularized.
You got regularized in 2012. Since
My
when
lord,
you
she
are-
appointed
2006.
as secretary in 2006. Then after 6 years, he was regularized in
The issue
2012.
is that, my lord, the respondent has approached the Lawrence Tribunal, and Lawrence Tribunal, after hearing both the sides, have come to the conclusion that the petitioner is similar footing with the Saudamini Nanda.
No, Saudamini Nanda was serial number 4.
My lord, there are 11 left out candidates. Out of them, 5 persons have challenged approached the Lawrence Tribunal for their appointment. Out of the 5 cases, in 3 cases, including the respondent cases, and Saudamini Nanda cases, the tribunal directed to give appointment. So, my lord, ultimately, my lord, Saudamini Nanda give appointment, and or left only one candidate, that is a petitioner. Another candidate, since 2004, he has not claimed. So, petitioner is only claiming. Nobody is claiming, my lord, since 1996. And the ground they have taken, non-selection of the respondent, that he has not verified the training certificate, that is thoroughly false. My lord, I have received the information through RTI in the year 1997. My documents were duly verified. And for these irregularities, the then DI of school and the inspector of school were punished by the government.
Inspect is not in the.
Yes. That has been annexed in the writ petition. I have annexed.
Where is that? Show that.
My lord, the RTI information, lordship. RTI information under Annex 2 of the.
You said that they have been punished, no?
Yes, my lord.
Yes, where is that?
Punished, my lord. Lordship, Annex 8 of the writ petition. Second paragraph, during 1997, some of the trained NFP instructor supervisor of the defunct NFP centers were appointed as regular primary school teachers by the then DI school on the approval of the inspector school, in which some violation of merit of such candidates were made. Not only the petitioner means, my lord, here the respondent. Not only the petitioner, but also some other person of that category had filed cases for different OAT for such irregular appointment. The then DIS and the inspector school have been punished by the government.
Yes, Mr. What is that?
My lords, in 2000, my lords kindly see that order dated page 24, Annex 3 of that writ petition, my lords.
No, even other way. You are saying that Nanda case is different. How it is different?
My lords, I have explained that.
No, that we have seen. We are not agreeable with that.
My lord,
they were also leftover candidates only.
My lords, the petitioner approached the Learned Tribunal in 1999, my lords. Kindly see, we have complied this order of the tribunal only, my lords. Annex 3 at page 24 of the writ petition.
What the learned judge has said now, single judge, if you have already regularized, what is that learned single judge has said?
From the date of that.
To extend the benefit as
Saudamini was given appointment in 98, my lord. Because the 4 regular vacancies were there.
No, Saudamini was also left out the candidate.
Left out 11, left out 11.
You have given appointment in
4 were vacant. She was 4. That is why 4 could be
Adjusted against.
Adjusted that regular post, and regular post was not there, and they in this ground they different.
Lordship, in the read petition annexure, they have themselves have to accommodate the respondent.
Where is it?
Lordship, I'm sorry.
My lords, a lot of facts are involved. In 1999.
No, if you have admitted that you have assured him that you will be accommodated.
Yes.
Then where is the case for us?
Annexure 4, Lordship.
We need not go for all the facts.
Annexure 4 of the read petition.
So that.
Lordship, page 27 of the read petition. Paragraph 3, my lord. As stated in para 3 above, 5 persons have filed cases claiming their appointment, but only judgment in case bearing such and such filed by Sri Bajokishore Das. That is the respondent, my lord. And filed by Saudamil Nanda, OA number 7, filed by Surendra Kumar Das, have been decided by the Honorable Tribunal with direction for appointment. In view of the availability of 4 vacancy of judgment received from the OAT in favor of the 3 persons, I request for approval of those 3 candidates for appointment.
Including your client also.
Bajokishore Das.
My lords, kindly see the very same letter, my lords. Raja Kumar Das was in serial number 101. And the persons who were given appointment, they were in 64, 67. How will leave senior persons and give less more meritorious person?
No, he has said, kindly see, as stated in para 3 above, 5 persons have filed cases claiming their appointment, but only judgment in case bearing number so and so. That's your case, so and so. OA number filed by Surendra Kumar Das have been decided by the Honorable Tribunal with direction for appointment. In view of the availability of 4 vacancies of judgment received from Honorable CAT in favor of 3 persons, I request for approval of those 3 candidates for appointment. As clear as the Gangetic waters.
My lords, this...
there is nothing.
My lord, my lords, another factor, my lord. This is in 2003. From 2001, direct appointment of teachers were abolished, freezed. It was by first they will be appointed as Shiksha Sahayak, then after 6 years they will be regularized. This is letter dated 2003. After that, from in 2006, he has given appointment as Shiksha Sahayak.
No, question is not that. That there is a district inspector of school is saying,
well,
these are our vacancies available. You accommodate him. Why, where have you commented in your appeal memo or in your objection to counter to this one, that this version itself is wrong? By virtue of this order,
what I humbly submit, there is a list. We cannot jump and give number 10 appointment, ignoring 1, 2, 3, 4.
No, the court, in fact, they went to court. Tribunal. The tribunal directed that. You should have taken up that contention when they were before the tribunal in OA number 3096 of 1999. Not now. Tribunal made the order.
All through the stand was taken, my lord.
You have taken the stand? Show that.
That is why, my lords, I from the beginning read a lot of...
No, when the authority says that accommodation, all these people can be accommodated because there are vacancies.
4 vacancies.
Yes, you accommodate them. Those who have come to court.
My lords, that way we will ignore earlier the number 1 person and give appointment to
that is not your ground. That is not your ground.
That is the ground in appeal memo also.
Huh? No. They have not taken up that ground.
They have made irregularity in 97 by not saying that we have not produced the certificate.
My lord,
they were punished. But from 97, my lord, this is 4th round release.
You have punished 2 officials. You have punished 2 officials, which he has got from the RTI, which he has produced. And there is not even a
It is-
whisper that this is not true, etc. No,
My lords, the first way, that is in 99, the tribunal passed order that you accommodate against the vacancies available.
Vacancies are available.
Vacancies were available.
Yeah.
That is how 4 persons were accommodated. My lords, this is the order dated 21/3/2001, passed in OA number 2244C of 1999. My lords. This order was complied with.
Dismissed affirming the reason given by the learned synthesis coupled with the research letter at the next 4, more particularly paragraph, last 2 paragraphs, which says that there are vacancies, 4 vacancies, and the respondent would be accommodated with that. This letter makes case of the respondent on par with Saudani. Yeah.
Item 33.
Yes, 33, your lordship may take in any other day.
2 weeks.
My lord, this will be taken up along with for reference WPC number 1007.
Give it. Right on it.
Yes.
Call on.
In this case, please.
Item 34.
My lord, date. Well, date may be fixed because of
Then 3. Yeah.
Wait, President.
Item 34.
The petitioner, the appellant Millard challenged the order of the Honorable Single Judge on 2 grounds. First is that Millard, the Honorable Single Judge.
What was the order of the learned single judge?
Well, Single Judge held that the order passed by the disciplinary authority as well as the appellate authority be confirmed. Because I read the question, my lord, the appellate authority and the disciplinary authority cannot be one and same person. Because your lordship may say that order that is passed under Annexure 5 and 7, that is writ application. The same person has, my lord, passed the disciplinary order, given the punishment.
You are the employee.
My lord. Annexure 5 and 7 to the writ application, your lordship may see.
What was your prayer?
My lord, my prayer was, my lord, because I was given a punishment of, my lord, 10% of the loss, that is, my lord,
recovery of loss.
Recovery of the loss.
10% of loss.
Loss, my lord.
Other 90% will be reimbursed whom?
No, they have stated that there was no such loss because of the finding of the inquiring officer to the effect that, my lord, there was no such loss to the cost to the government. But the disciplinary authority, my lord, being disagreed with the, my lord, finding of the inquiring officer, my lord, he has stated that no, I am not agreeing with that, but you have to, my lord.
But notice was given to you.
Yes, my lord, notice was. And I also submit my
before disagreeing with the finding of the inquiry officer, proposal notice was given.
That was given, and I have also replied, but that was never taken into consideration because the same thing that was submitted by the inquiring officer, just that is reiterated the in the explanation. That is disagreeing with that. And the second thing is, Millard, your lordship can have a glance. The first is, your lordship can have a glance, the Annexure 5. That is page, Millard, 70.
Proceeding
83, Millard. Relevant page is 84.
10% coupled with one annual increment.
One annual increment. That is, my lord, by the additional chief secretary, my lord, the same person, that is annexure 7, your lordship may see. The same person has also, my lord, being an appellate authority, has confirmed his own order. Annexure 7.
Secretary to the government.
My lord.
This is the order of the office order. This is the order of punishment itself.
My lord, punishment itself.
And the appeal is by whom?
My lord, I prepared appeal before the governor.
Correct, governor.
Governor.
Who decided?
And the same person, my lord, this disciplinary authority, the additional chief secretary, he decided and confirmed his own order. That is page, my lord, 94.
Additional chief secretary to the government.
My lord.
Appeal against the government order.
My lord.
Was to the governor.
Governor.
Order of the government or order of which authority?
Order of, my lord, this disciplinary authority, that is, my lord, additional chief secretary.
Additional chief secretary is also government.
Government.
And then goes to the governor.
Governor. But he again here the same and confirm his own order.
Same person.
Same person, my lord. Your lordship may see that signature.
No.
In page 84, your lordship may see that the signature.
In the Maruram.
My lord.
Maruram versus Union of India, 80 Supreme Court, Constitution bench say, governor means shorthand for the government, president means shorthand for the central government. But where rules provide for appeal from government to governor, then governor has to independently look into that.
That is
the law.
Matter.
Is there any change of that view by the apex court? There may not.
No. But my lord, this matter, my lord, last night I have gone through the brief, but it's not properly arranged. No documents are not properly arranged. Therefore, I am little hesitant to conduct this case because.
We'll give you a short time.
Monday.
Come back. How is your health now?
None. It has recovered.
Recovery. We'll call this matter on 12th of February.
Yes.
12th of February. No, 12th we have matter. No? See, when we say the day, you have to look into the day. We should tell whether to call on that day or not. Which day is it? 12th, how many cases are posted on? Okay. 12th will have.
My lord, second part is that even if accepting that, my lord, only recovery is, my lord, 3,60,000. But entire amount, this person has to get, my lord, more than 1 crore. But the entire amount has been held up and is not been paid any.
Other amount is payable to you.
My lord.
So you will be agreeable with this recovery.
My lord, that is subject to, my lord, your lordship's final adjudication of this appeal, my lord. But so far the other dues are concerned, they are admitting, my lord, admitting that this amount is to be paid.
Just look into.
Yes, I will take instruction, but the vigilance case is still pending.
Vigilance case is for what?
For that
punishment.
No. Recovery may be.
Recovery also.
No.
Recovery is here.
No, recovery is here, but if he is held responsible for embezzlement or whatever.
He can be punished. But how recovery can be done?
So I have to.
And there is a clarification to that. Your lordship may see that clarification with regard. Even if there is a pending of the, my lord, vigilance case, that is their, my lord, clarification.
Only thing is the special court can award
imprisonment
and the fine also.
Fine.
Any limited fine there? No. Fine also, any amount of fine. But how can you withhold the amount payable to him?
Yes, that has to take it slow. Yes, that has to be also.
Because in the last paragraph, your lordship may see that the first.
Anyway, you retain that argument so that you may not spend that point. If you argue now, other day we will not permit you to reiterate the same. Next.
Item 35.
Right, person.
Yes.
May please, person. Here is a case, lordship, where 2 orders have been challenged. That is at page 23, prayer portion, lordship, passed by the land Central Tribunal, lordship.
Here is a case, Lordship, where the
What was the order?
Lordship.
Earlier
The-
order?
Lordship, the relevant portion of
29-10-24.
Lordship, the relevant portion of the order where we are getting agreed, that is at page 44, running.
No, we are asking what was the order dated 29-10-24?
29-10-24. Yes, Lord. In that order, Lordship, while the case being admitted and notice issued, here the Honorable Court has been pleased to observe some contention based upon judgment that the state of UP versus Sudhir Kumar Singh and others. On that score, it was a case of natural justice. We have tried to ventilate this Honorable Court that there is no violation of any natural justice. Enough opportunity is given to the applicant petitioner in that case before the tribunal. And for that reason, this judgment was relied upon, and based on that only, Honorable Court is pleased to issue notice to the appeal parties. And now the appeal parties appealed also. That is the order of the
So that judgment says mere violation of principles of natural justice is not sufficient.
Not sufficient.
There should be demonstrable prejudice because of violation.
But in this present case, Lordship, there is no such gross violation of natural justice because the applicant, that is the charge officer, has participated in the proceeding full-fledgedly. There was no issues. But the technicality involved in this case is that beforehand, I may attack the story of the case is that the present appeal party, who is the applicant before the land tribunal, during 2008, he has been charged sheeted for a misconduct that is regarding abusing of a female because he was a dental assistant. And during 2008 also, he has been charged sheeted and has been penalized, and that was never challenged by him. Again, 2012, the same person has committed similar type of offense or this misconduct, which has created this entire issue. Basing upon that, one inquiry was conducted.
What was the allegation?
Allegation, Lords. Allegation, Lordship, may I read, Lords? Here the allegation, Article 1, the charge article is that, may I read the short point, Lordship? Sri Vishwanath Pavida, the present charge officer.
Page?
Page, Lordship, running page 88. 88. May I please, Lordship?
Don't read the names.
Right. I will not.
Without reading name, you say.
Right.
Many people will be seeing.
Follow. I will not. The Article 1.
Hospital, so and so, 2 photographs, and 1 video clip of a minor girl, so and so, mobile number, and display for obstruction, and put on English to not subsequent to this it showed the hard copy of the so just to also for the share the photograph and video pictures of the person and the other thing hard copy of the without the content of that. And considering the point on the part of the so past record of suspected transactions for using the communication. After the charges are imposed, no one ever exactly what you want to wait for that penalty he has not challenged?
No, not challenged.
Did you challenge the penalty that was handed to you in on 3/1/2006? Sorry, 1/8/2006 for misbehaving with the lady. Your client.
1/8/2006, I don't have any idea, but I have not that whether he has challenged or not. That is, I do not know. But it is in respect of 2012 issue, Milan. This case relates to 2012 issue, and they have initiated the proceeding. First proceeding, then inquiry officer was nominated by authority. Inquiry officer submitted the report.
Come back. Just one sentence.
This is a fact that he has not challenged that one, the earlier order. Subsequently, 2012, same allegation, again he has committed. For that, an inquiry was conducted. But, after the inquiry, as per the Rule 15, we have followed the procedure. But somehow that was better of a challenge for the learned tribunal. And learned tribunal has been pleased to hold that, no, this is not as per the procedure prescribed under Rule 15 of the CCCC rules. So you go and again follow the same procedures from Rule 15.
Set aside and
set aside all these things, Lordship. Based upon the observation of the Honorable Learned Tribunal or the National Learned Tribunal, we have again started the entire process from Rule 15 only. Here what happened, in the initial inquiry conducted by the EU, the inquiry officer, one Rajesh Barrier was there, that in that report there were some infirmities found by the DA, disciplinary authority, for which the DA felt it proper to assign the same inquiry to another person. There is no way that it can be done. But after the order passed by the Learned Tribunal, passing the first one, when
there was already an inquiry report
is there,
that unless that case falls in that parameters of apex court decision, you can't just go on changing the inquiry officer till you get a favorable report.
No, not in fact, there were some charges were disproved by the EU, but there were some materials for which only the DA felt it proper to go for further inquiry.
No, you cannot go that way.
That way to justify before assigning. That is the basic thing. That way to justify.
On your own, you can differ from the findings of the inquiry officers and a proposal notice to him. Inquiry officer, though this is so much material is there, he's saying like this, we don't agree.
Right.
We want to reverse that finding, or what do you say?
Right.
He will give his reply if he wants. Then you can take a decision.
Right.
But you can from one inquiry to another, you cannot go on shifting the inquiry from hand to hand.
Right. That is one thing, let's see. But there we have to give a reason that why we are adopting this.
Why you want? You have to discredit the inquiry officer.
Right, Lord. So that we have to give a reason. That reason was assigned. And after that only new inquiry officer appointed, and he has also given his finding. Now here the issue is that, Lordship, while as per the orders passed by the Learned Tribunal, when the second de novo inquiry was conducted, there the DA had supplied the first inquiry report made by in the first inquiry to the charged officer, and thereafter again the DA has conducted another inquiry by himself, and that document was also supplied to the charge officer for his reply. Now this became a catch in the case, as I found from the record. What Learned Tribunal holds, that if you are adopting the second one, then you have to follow the entire procedure prescribed under Rule 15 of the rules. As because that has not been followed, the entire consequential things, because he has been found guilty and appeal was confirmed everything, because you have not done that one appropriately, for that reason the entire thing has been set aside or passed and directed us to again follow the Rule 15 procedure afresh. That is what is the matter of this before Honorable Court, Lordship. For that reason, we had filed one review application that was also denied by the Learned Tribunal, and for those two orders I before Honorable Court on the ground that if at all it is a case of 2012, now we are in 2026. If at all we will again follow meticulously the rules prescribed Rule 15, then there will be some practical issues which cannot be meted out. The reason is that the victim girl, now she must be around 30 years old. We cannot again call her and go for a further examination of further inquiry. Similarly, some witnesses, those who are there, some were retired, some were also posted somewhere else. Now, the thing is that if at all we are going to honor the order passed by the Learned Cat or the tribunal, Honorable Tribunal, then these are the practical problems which we cannot afford. But based upon the only one technically that as because in the second inquiry report, we have not adhered the strict guidelines of Rule 15, if the entire thing will be given a go by, then that will otherwise cause the injustice. And it is a fact borne after the record that this charge officer has participated full-fledgedly in the subsequent proceeding. There is no dispute on that score. So now the question is whether it is a case of violation of natural justice, whether it is a case of that opportunity has not been given to the charge officer. My understanding is that it is not a fact. Pardon us.
We are not.
Somebody. So this is what the points to be considered in this case. This is not a case that he has never been given any opportunity of hearing or participating in the proceeding. This is not the case. Case is only based on a technicality. Now, if you go by the books or the rules, Lordship, that the Rule 14 itself says that the DA can be an enquiry officer. May I read that sentence itself with permission, Lordship? This sentence starts in this way.
He himself can hold inquiry and pass award punishment also. Is true.
That is followed, Lordship.
Yeah.
Here, Rule 14 surplus 2 says, only 3 sentences may I please, Lordship. Rule 14 surplus 2 says, whenever the disciplinary authority is of the opinion that there are grounds for inquiring into the truth of any imputation of misconduct or misbehavior against a government servant, it may itself inquire into. That is available. So the issue that how you became an inquiry officer and how you are supplying.
Having appointed inquiry officer, inquiry proceedings having been held, report having been submitted to you, you do not agree with that, then you cannot become the inquiry officer.
The only thing that if the DA found that there are some infirmities in that inquiry report, then
if there are infirmities, see that's what on. In you mean to say,
sir,
the tribunal should not have set aside the inquiry proceedings, and it should have acted up, at least it should have permitted you to take a decision on whatever material is now collected.
Yes, in the subsequent inquiry. The subsequent proceeding, whatever materials is collected, that's because those things, the charge officer has himself admitted that, yes, these are the mistakes done by me. There is no dispute. So, but the record is concerned. That there is no dispute.
No dispute.
No, that my friend can assist also.
Where in his reply he has said, no, he has taken the photograph of that girl in the video, in the
mobile phone.
Appreciating the beauty of that girl, and he enlarged it and photo frame to present it on her birthday.
But with an intention, ill intention. That is what the complaint raised by the parents of that minor girl. For that is also
violation of privacy, especially after Neena Gupta and Swami. This we can understand.
Right, sir.
But is it such a misconduct where
to be taken very seriously? That is what Lordship's intention. But it is a repeated offense. Lordship kindly see in 2008 also same thing was done.
Proximity.
Proximity, yes.
Proximity. You suppose if it happened about 25 years ago.
Then we can understand that.
Everything memory is erased.
Right.
And as a fresh person, he does so. Unless proximity is shown. Proximity between other incidents.
Right.
That proximity has to be shown. That happened in 2006. This happened in 2012. 12. After 6 years. Where is the proximity of two incidents?
No, this shows that how a government officer is showing his misconduct or dereliction of duties and how he is abusing his authority. That is what the imputation made against that person. And in the first allegation, he has never disputed. He agreed, yes, that was somehow done. In the second also, in the full-fledged proceeding, he has also never disputed that this is not done. He has participated in the proceeding.
What is the punishment you had imposed earlier?
In the earlier one, Lord.
No, not this only.
The present one. Yes, Lord. In the present, major penalty was given, Lord.
What was the punishment you had given?
Major penalty.
And privacy judgment had not yet come.
That was not it.
It had not come. It came only in 2016-17.
the imposing punishment by the DA retired Sandesh Satar. Annex A/7.
What is the punishment?
Annex A/7, that is Your Lordship, learning phase.
Your Lordship, kindly turn to page 112.
110.
You are asking.
110.
We are asking you how many teeth you have got. You are opening the mouth. I don't want to count. You tell me, what is the punishment awarded?
That we reduced to 3 stages from rupees 37,000 to 33,900 in the time scale of pay of level 5 in the pay matrix for a period of 5 years with effect from 1/8/2018. It is further also that B. Parida will not earn increment. That means cumulative impact. And I have already retired in the meantime.
You retired, but why did you do all these things?
No, my lord.
You should have kept in view, I am going to retire. I want to have peaceful evening of the life. Whether what I should do, what I should not do. Controlling the mind. Where is that?
My lord, 2012, my lord, I am suffering. They are not unable to complete the proceedings since 2012. If your lordship will give me 3 minutes time, my lord, only I will show the Honorable Tribunal's order. I will not say anything. Your lordship may kindly see the Honorable Tribunal's order itself. First order, that is at page
now you tell us to put an end to all this. What should be the punishment? So that once for all everything will be over. Otherwise they are going to hold the inquiry against you.
No, my lord.
You will have so many sleepless nights.
My lord, I will be obliged if the inquiry will be conducted and I will be penalized. In fact, there was no, because
you have admitted.
In fact, my lord, superintendent and myself, there was a conflict. Superintendent has, my lord, I gone there and I have admitted, my lord.
Yes.
And a superintendent and myself, there was a conflict.
You have
all these
having done all this. Well, the superintendent tell you, did he tell you that go and take the photograph of
photograph in presence of the parents? I have taken the photograph. I have displayed in the board for general awareness. I'm a dentist.
One of the manner.
No, my lord. Again, I will say, my lord, I am a dentist, my lord. Prior to taking the clinical,
that is for clinical purpose you can take. Previously and subsequent to the treatment.
Previously, allegation is I have misbehaved. I have misbehaved.
That as dentistry you can take.
What about the person you have taken? And you wanted to present it on her birthday.
No, my lord, I have that has been presented in the board and somebody has taken and misused the same. My lord, I do admit that in my humble submission, in presence of the parents, after taking approval, I have said before.
Present, they have given complaint.
Then subsequently, that has been on the pressure of the CFD complaint. No. And my lord, my humble submission, my lord, again.
Our humble submission is this. For a dentist,
my lord,
beyond the dentist's photograph, what is required?
Nothing.
Why did you take the entire photograph, the full personality photograph?
Not personal, only face, my lord.
Why did you take the face? Face is the index of man.
Before that, before
surgery,
all the teeth were out of the face.
That's all.
And surgery that was within the both.
Only that person you should have.
Yes, we have, my lord. I have, but that entire face, your lordship is right to point out. That is the, in fact, my lord,
you take the photograph of face, you have to face the problem. Therefore, we are now suggesting, you are in the evening of your life post-retirement. Instead of going on and on like this, you suggest some punishment so that we will once for all.
Without cumulative effect, your lordship.
But it's appears to be very sensitive.
Yes, is very fine. I can, if you lordship, single day. Tomorrow I will be in a position to reply on this point. I have to take a departmental case, lordship. So I cannot take on my disbursement. Tomorrow I will come with reply.
We suggest during the course of hearing, having turned the pages of appeal paper, the petition papers, appeal papers.
Yes, lordship.
Come on. We found that keeping this inquiry in respect of an event that took place in 2012 in continuation is not in the interest of any party. And therefore we suggested that if both the sides agree for a lesser punishment than awarded, the entire proceeding itself can be put to rest. First, learned counsel appearing for the respondent employee very fairly submitted that his client is in principle agreeable with this suggestion, provided that the cumulative effectivity is removed. However, learned counsel appearing for your CGC,
Myself,
panel counsel,
senior panel counsel, Rajesh Pramapati,
appearing for the appellant, seeks a short accommodation to confer with his client, official client, and come back. Call this matter on 12 2.
Yes,
for order that once for all we can.
Yes, we can close.
For order, so that it can.
No, not. It may say,
Sorry,
it may come in
for
regular
this
course.
purpose.
Only for this.
Like,
Yes.
on that, I will let him proceed. My name may be, my name is not there. I will give you right.
Yes.
Grateful.
You just think. So because it is arguable this side that.
I followed it. We will give a full stop on this part.
That's all.
Grateful.
Yes.
Grateful. I'm grateful.
Because he has retired now.
Right.
Yeah.
We should give a.
And that girl has attained majority.
That is what.
Her husband may not agree. That
Otherwise,
she
you
should
should
go and
speak up.
report.
Yes.
Unnecessarily, tomorrow it may appear in the newspaper also.
Everything will happen. Yes.
So
Right.
once for all, everything.
We'll give a full stop.
Righteous to them.
Right.
Yes.
Just a bit. Grateful.
Item 36.
36, my lord. In the past case, notice was issued and I am appearing for opposite patrol respondent number 2 and 3. For so far the second is concerned, it is no notice is yet issued, but I have voluntarily appeared for 2 and 3. Let my learned friend serve the copy on me.
Sir, can you serve a copy on?
I'll serve a copy.
Well, we can call this matter.
Before that, I will only take your lordship to one thing. I require an interim protection in this case. And there are two contempt petitions which have been filed against the bank.
Don't precipitate the contempt matter until you take. Now you want time. Because you want
I have not taken my lord.
You don't
my lord, here, no notice was issued in the second case, but voluntarily I appear, but not a copy not served. I don't know how is that case.
Learned counsel is saying,
yes,
I will serve copies. I'll give 1 dozen copies to.
Yes, my lord. Then my lord,
you should not precipitate the contempt matter.
Your lordship may kindly say, I have also filed one affidavit today and an IA to call for the
Read petition.
Yes, copy of the read petition. Earlier they have filed. That is relevant for this purpose.
They are part of the record.
That is part of the record. That is those are part of the record.
No, that is not part of the record. This not this record.
No, that annexure also I have given in the writ petition, writ appeal also. But the interim prayer is
in terms of application number so and so. What is that IA number?
IA number, my lord.
IA number so and so supported by affidavits. Registry is directed to place before place the record of WPC number.
WPC number, my lord. My lord, that is one OJC number.
OJC number
13193 of 99. And another, my lord, WPC number 8906 of 2007.
2007. Along with the appeal book. First, learned counsel appearing for the appellants submits that 2 contempt proceedings are hanging as the are pending. Are pending.
And in one they have appeared against the bank.
Learned single judge.
before the learned division bench, they have filed, where there is a contempt which we have filed, where notice has been issued in that contempt.
We have appeared and filed out for cause.
593 of 2025.
Before the division bench?
Before the division bench. That is 2025. That matter will also come before your lordship.
Come here only, no?
That
We'll
may
say
be-
call that also with us.
Call that matter also.
Pending. And they also may be called along with this. But no, the suggestion is sensible. But no. Call the contempt, the cases in contempt of context-wise society. Along with these officers.
Well, lords, I have filed an IA for stay.
Today,
Please. After working for 30 years, 30 years, we were suddenly, after the judgment of the bank, there were two judgments of this High Court, in our case only. A division bench directed that our case shall be considered for regularization. One, that since we have put in more than 12 and a half years service, that record which your lordships is now calling for, in that petition was allowed. We contest with the bank, and my learned senior Mr. SP Mr. appeared for the bank, that for State Bank of India in that case, and he placed all the records. And after hearing both the parties, the division bench directed that our case shall be considered for regularization. So what happened? They did not regularize our services. So again, on the that posts are not existing. State Bank of India, they are submenial staff, class 4 employees working as sweepers. So thereafter, again, I filed a case for regularization, that they are not taking steps for regularization. That time the matter was assigned to the Honorable Single Bench. And the Honorable Single Bench said that regularization matter, that he took a different view. The bench took a different view, for which this writ appeal was preferred, because that judgment is binding upon the single judge. And the materials on record is that by now they have completed 30 years of service. And so far as bank is concerned, they are guided by certain settlements.
No, we are asking you, what is the interim protection?
Interim protection is that we may be allowed to work. We should not be, because we...
So long you are out of the employment now.
Yes, they immediately after the judgment...
Which date? Since when?
My lords, they have issued me a notice which I received. Your lordship,
Since when you are out of...
We are asking just a date.
Since when you
How
are...
long you have been out of employment?
I'm just giving They have sent me a notice by virtue of which they have immediately said that you are out of service.
When?
That is under Annex 1 in the country, my lord. Just do one second, page 14. Page 14. That is, they have given the notice on 19/7/2025. Immediately when the 19/7/2025, I filed the contempt petition because they have violated the order of this honorable court, wherein notice was issued. So far as issue of stay was concerned, notice had also gone that they said that the honorable the Chief Justice said that you file contempt application if they are violating in contemplation, and the matter thereafter would not be taken up.
My lord, we will have it short date.
Your lordship, there is the date, but this order may be kept in abeyance, this notice of 25F, which they have...
We will not do anything now. We choose a date from the February month calendar.
My lord, on top of the list, it may be kindly taken up on Thursday.
Top of the list, very difficult, because we do not know which matter.
This matter, whatever my learned senior objection, that may be taken note of now only, because we will finish your lordship, I pray to close the case. Because after 30 years, they did not give us temporary pay also. So these two writs were clubbed, and two writ appeals are before your lordship. One is temporary pay. That temporary status you have to confer us once you are working for 270 days. Your lordship, we call it on 12th. If your division bench.
18th we can have. 18th, 12 matters. Yes, how many matters? 12, 10 matters. 16. 3 matters. On 16th, you will have this matter.
Matter on top of it. I pray that the only thing, my lord, humble request, my lords, that may be acceded, my lords.
Yesterday, I have filed an affidavit that we have retained them from their job. Following the due procedure of Law 25F is compliant, money is paid.
And the contempt matter, your lordship may kindly call also, when they have appeared.
We have already ordered. Ordered, they will also come.
4593. Contempt petition 4593 will come.
Item 37.
Sleep this matter. Item 37.
Yes, Mr.
We are appearing for 2 and 7. We have in the writ appeal. We'll file an affidavit. I just informed the petitioner.
The appellate, I have received the reply. Your lordship will kindly take your lordship's last order of 25th November.
All
this will not be necessary.
We are just seeking time to complete the pleadings.
No. We may just tell you. We have taken instructions, my lord. In fact, if your lordship only just to keep on record an affidavit, we are saying your lordship by 16 will file an affidavit. Your lordship may
file my rejoinder.
Whatever they want to file, they can file in the meantime. I mean,
I will also file respond number 3, 4.
We'll file.
The opposite party 8 has already filed its affidavit, my lord. Opposite party 8, we have already filed our affidavit. The 19th December.
2 and 7 is Leonard Senior's representation.
May I say, lordship, respond number 2, 3, 4, 5, 7 will file their affidavit. Of course, joint affidavits.
3, 4, 5.
3, 4, 5, I'm telling for him also.
I am happy.
For him also. Then your lordship said
Respondent 2, 3, 4, 5, 7 to file the affidavit on or before 16
February.
Feb 2026 after serving the advance copy on the other side.
Then the respond number 8 has already filed an affidavit. They are wanting a rejoinder. Let them file a rejoinder.
Number 8 has already filed the affidavit.
And appellant wants a rejoinder. In the meantime,
it is open to the appellant to find the rejoinder.
If any. Yes. Lordship may fix a date then.
Then 16 will not be served.
No, 16 will be the date for filing. So Lordship may fix it any time after that.
All this matter.
We commence 23rd.
As your lordship, as your convenience. Yes.
First week of March.
No, first week of March, there are some holidays with that holy, you know.
The 23rd February, if it appeals to your lordship, 23rd.
23rd, I think matter is short. 23rd,
all right.
Yes, lordship, that is short matter.
All right. All this is
grateful, sir.
Well, it's one short prayer.
OP6, this reply. OP6 is the Tahsildar Koida, who my learned seniors.
They want to file, they will file.
Their replies.
Then they are not required. Not required. No, your lordship need to insist on that.
How can we tell you file this?
If they want to file.
Can the court say to the defendant to file the WS?
Not necessary.
If they file, well, if they do not, we'll take advantage of it.
Very well. The reason is that there are certain correspondences made by the OP6 which are in my favor.
No, that is not. In fact, that will be decided. Documents are there. Documents are.
In fact, the case could have been heard today by your lordship and disposed of without anything, without affidavit. But for abundant caution, since we have public sectors, we just want to keep the affidavit on record. The lordship may call it on. Grateful.
One small prayer. Writ appeal number 1310/2025. Since they have already rendered appearance, I'll serve a copy so no notice may be issued that your lordship may reflect it in the order sheet. Writ appeal number 1310.
I'm going to be appearing for 2 and 3 in that case, sir.
I'm not holding vakalat for 1.
We request you to accept notice for that.
Already?
Yes.
The panel counsel sheet going to request it to accept notice for 2 and 3. In the same appeal.
Yes.
It's all bank.
Second appeal. In both the matters, I am appealing for 2 and 3. But so far 1 is concerned, notice has not been issued.
Notice will go to opposite party number 1 if my learned senior is selling his all our bank employees.
Let's go to opinion.
OP number 1.
In both the matters, in the first case also, it was not
if we
sufficient.
issue notice, we can't fix a date.
Oh, that is the let's let it lie over.
Without notice only, with the OP number.
No, OP number 2 and 3, because that is what they want to delay.
No,
the only intention is that because we don't have an interim protection.
Notice how
your lordship.
OP number 1. You have made OP number 1 a party.
Well, it's just one.
No notice need to be issued to him.
My lord, the OPs are, well, at once, just 1 minute, my lord, just we granted the opposite party.
Is the chief general manager, CGM?
My lord. same area, and I don't know why my learned.
No, for him to say accept or not to accept.
My lords, this is the CGM is appearing State Bank of India, CGM is Bhubaneswar. Then Deputy General Manager is also Bhubaneswar. Then Assistant General Manager is also Bhubaneswar.
Correct.
So those three are Bhubaneswar, and in the same office located is just 500 meters here and there.
Should we not order notice to him?
The CGM, no, that is what, because if he's authorized, the bank is authorizing my learned friend to appear for only 2 and 3. But he says that I have not been authorized by the opposite party number 1. No,
that they have chosen for him only for 2 and 3. He can appear only for 2 and 3.
Correct, my lords. I don't have any qualms over that. But the question is, my lords, once your lordship that will say that notice to go to, but to opposite party number 1, then my lords, I am undone, my lords.
How you are undone? Can we pass, allow your appeal without hearing the OP number 1?
My lord,
therefore, let notice go to OP
State
number
Bank is 1. State Bank is 1.
OP number
so,
1.
But if they, my lords,
emergent notice to OP number 1. Call immediately after. Don't fix the date. Call immediately after service. Yep.
My lord, your lordship fix a date.
How can we when we are issuing notice, we are not supposed to fix that.
But then in the interim, I pray for my interim relief because I am not this poor person.
Interim relief is rejected in as much as all they have been issued. Is it retrenchment?
Retrenchment, yes.
No, they have my lords, let it lie over.
In July 2025.
My lords, I may be excused.
How, sir? You say notice need not to go. You say you should be given protection. How, sir? How is it possible?
They add interim protection because of the
No, in July you have been retrenched. Compensation has been retrenchment compensation.
No. What is, my lords, the catch is that after the single judge has delivered the judgment, there is in violation of this honorable court order.
Therefore, you have filed the contempt.
That is why contempt.
Therefore, we are asking the contempt also to come.
So, contempt may be fixed earlier.
No,
this true because contempt notice has.
Suppose if we want to take action in contempt, and tomorrow this appeal order is set aside in your favor, then what should happen? Therefore, we wisely, with some experience, accumulated experience of the judges, as judges, we have said, let the appeal and contempt proceedings come here. So that we can look into both. What is the conduct of the party, etc. These things will decide.
And in the first writ appeal, notice has already gone to all the parties. And he has appeared for 2 and 3. One has not appeared.
It is not sufficient on OP number 1.
No.
That is the noting.
Your lordship.
Yes. OP number 1.
My lord, that already we have notices, we have given the copy. It has gone by speed post. And
it has not come. Therefore, in your interest, we are telling. Otherwise, again, it will be adjourned. Without hearing OP1, how can we pass any order? And he is holding brief for 2 and 3. He says, I cannot hold, unless they say, how can I hold brief for OP1?
I cannot compel anybody to engage me.
Issue emergent notice to OP number 1 in both the appeals. Firstly, into fresh order. Learned panel counsel, Sri so and so, on our request, accepts notice for OP numbers 2 and 3. 1, 2, 3.
2, 3.
No, there are only 3 parties. No.
There are only 3 parties.
First one.
2 and 3.
Post this matter, along with contempt is so and so, immediately after service, on OP numbers 1, OP number 1, in both the matter. Yeah, this will help you.
By speed post? Or by
issue emergent notice to OP number
1. My lord.
Copy will start by tomorrow.
Kindly give copy.
My lord.
Yes, thank you.
The next matter I have.
Next matter should come on.